I will allow my registrar to call the matter and then thereafter request the lead counsel for the parties to place themselves on record, and then I'll do some housekeeping before we proceed with the actual hearing. Jimmy?
Thank you, Judge. Full court, third court matter before Mr. Justice Davis, Madam Justice Collis, and Mr. Justice Nyati. It's case number 005779 of 2023. It's the matter of United Democratic Movement and others versus Eskom Holdings SOC Limited and others.
Thank you, Jimmy. The lead counsel for the parties, if they can place themselves on record.
I'm sorry, my lord. It looks like there's an echo on my side.
Yes, Mr. Nkatobe.
No, I asked to use my computer, so just switch off your system.
I'm still trying to sort out the.
You're for the applicants, except the third applicant.
Now it looks like it's been sorted.
Yes.
My junior has helped me out. I appear for the first 19th applicant, the exclusion of the third applicant.
Yes.
Together with Ms. Talk, Ms. Mkize, Mr. Gwala, Mr. Kwabe, Mr. Masuta, Ms. Richards, Mr. Pierre, Ms. Joey, and Ms. Rasasemola.
Thank you. Mr. Dyke?
Thank you, my lord. It's Bruce Dyke. I haven't had an opportunity to formally introduce. I'm from the Eastern Cape Bar. I appear on behalf of the third applicant together with Benson and Nadesan.
Yes, thank you. Mr. Bum?
Thank you, Justice. There is an echo somewhere. Justice, I appear for the first respondent, Eskom, together with my learned friends, Ms. Steinberg, Mr. Duplessis, Ms. Nyembe, and Ms. Blizzard.
Yes, thank you. Mr. Tsatsawane?
May it please the court, my lord, I appear for the state respondents together with my learned juniors, Advocate Hasim, Chavedi, and Ramaimela.
Thank you. Thank you all. We're principally online at the request of the parties. You know my view. And seeing that the reasons for the online hearing will have dissipated by today, if we proceed on Wednesday, we'll proceed in open court. Further, for housekeeping, whilst we are hearing the matter, and to also limit clutter and echoes, I'll request that only my colleagues, my sister Collis and my brother Nyati, and counsel then actually arguing have their camera feeds on and their microphones on, and all other parties their feeds and microphones off. Having said that, regarding housekeeping and how the matter proceeded at the case management meeting earlier, it was agreed and directed that the counsel for the parties have estimated the duration of argument for the applicants would be 4 hours, for the respondents 4 hours, and for the reply 1 to 2 hours, and counsel will arrange the distribution of time among themselves. Before just giving Mr. Dyke an opportunity to say something, I should also acknowledge the counsel for the seventh respondent, Mr. Manechi, who said that they have filed a notice to abide, but there will still be appearance by way of a watching brief.
Justice, if I could just get in there. I am Pumzile Sokela. I am on a watching brief for NERSA and for the seventh respondent, and our notice of abide is at 24-7 of case lines. So I will be observing on behalf of NERSA.
Thank you, Ms. Okela. We've so noted it at the management meeting as well. Mr. Dyke, I apologize that the notice for the management meeting did not get to you. and I saw your attorney's correspondence subsequent to that. The two matters of substance raised therein, I think, were firstly that your exclusion, and secondly that you also supported an online hearing. Please accept our apologies. Is there anything else I need to know on behalf of the third applicant at this stage?
No, my lord. We have already spoken between ourselves, and we won't be repeating issues. So we'll be very limited.
Thank you. Then, as I mentioned earlier, just the limited camera feeds, and Mr. Nkaitobi, you'll set the example when arguing first to note that when one of the judges raised their hands either electronically or physically, it would have meant that in open court they would have wanted to address a question to you, and I know you'll respond. Having said that, on the applicant's papers, we are online. It would have been in open court, but it is, of course, not a political forum. It is, of course, a court of law. You will have also noted the first respondent supplementary note regarding certain issues which they suggest have been factually incorrectly mentioned in argument, and I assume you'll address that. Before handing over to you, on behalf of my colleagues, we would also appreciate it if during the course of your argument, you can address two principal issues. The one is, why do the applicants say the relief in prayers 3, 4, and 5 constitute interim relief, and why it's not effectively of a permanent nature? And the second thing is, of course, you'll have to address us on the issue of separation of powers. Mr. Nkaitobi, you can accept that despite we having been in court last week and having heard other matters, we have subsequently read the papers and we've read the heads of argument. But otherwise, we're over to you.
Thank you, my lord, and I'm also grateful for the indications of the two areas that the bench would be expecting me to address, the issue of the finality of the order and the issue of the separation of powers. What I propose to do is not to deal with them separately, but to integrate them in the structure of the argument, because these are points that are indeed taken by the respondents as well. I am going to address 5 topics. The first one is to briefly recalibrate the evidence as to the impact of load shedding and the rights that are impacted. The second is to deal with the issue of who exactly should take responsibility for the impact of load shedding on the rights that we say are affected. The third issue is to set out the legal obligations. I will be relying for the prima facie part of the case on the judgment of the Constitutional Court in Vaal River. In fact, it puts paid to the complaint of separation of powers. The fourth would be to consider the primary relief that we ask in respect of the exemption. And the last would be to consider the alternative relief, which is not the exemption per se, but it is an order that the respondents should take steps to put interim measures to ensure that the facilities that are identified in the notice of motion are not affected by load shedding.
Yes, thank you.
Let me then deal with my first topic, which is the recalibration of what the evidence is. Much of it is not disputed, so I will be brief, but my being brief is not a sign that this is not important. In fact, it is central to the case. We have chosen, as the court has noted, on the evidence, to address the impact of load shedding on the health sector the impact of load shedding on clinics and hospitals. Much of this comes from the practitioners as well as the nurses in the hospitals themselves. And Professor Mativa's evidence is probably the most instructive. And the court will find this in the founding affidavit at 03/31 and the actual annexure at FA4, but the evidence at 03/31. What she says is that when there is no electricity at a health institution, there is damage to medical equipment, which makes it unreliable, and that renders it life-threatening. The data processing operations break down. They reduce the efficiency of hospitals. Thirdly, the central heating and cooling systems are damaged. They are rendered non-functional. Fourthly, the impact on newborn babies who suffer from hypothermia or hyperthermia, which can also kill them. Fifthly, they are unable to control or implement infection protocols. Sixthly, the laboratory services are dysfunctional. Seventh, they cannot properly store specimen, which also makes the test results inaccurate. 8, pharmaceutical drugs cannot be properly stored. 9, procedures that are urgent in respect of certain patients have their surgeries cancelled, which worsens their conditions and they become even more urgent. 10thly, the integrity of the medication, which must be stored at specific temperatures, is also compromised. And 11, ventilators, oxygenators, and home treatment that need to be charged. But because of the unreliable load shedding timetables, there's simply not enough time to recharge them, which causes people to suffocate. And in fact, Professor Mativa uses the example of her own grandson who almost suffocated to death as a result of this problem. She then concludes her evidence by saying there have been several instances where patients succumb, in other words, they die, and the cause of death is described in many different ways. But in reality, the cause of death may have actually been due to load shedding. That evidence is corroborated by the Nurses Union, which does not focus only on the impact of load shedding on patients, but focuses on the impact of load shedding on the workers, the nurses and the practitioners. Where they start off, and you will see this at F0316. And they start off by explaining that when power goes off and the nurse is overseeing the delivery of a baby, they firstly say, euphemistically, a lot can go wrong. But they explain what they mean when they say it is a matter of life and death because the mortality rates go up with every power cut, especially if a person is on resuscitation or oxygen. If things don't go as planned, someone dies every time there is a power cut. This evidence is also dealt with in a note by the Department of Health itself, which says the security of the health facilities is also compromised during the blackout times, especially in the evenings. And it also has an impact on the security of the health workers who feel vulnerable, and therefore because they are not safe. You will see that as FO315. So there is overwhelming, irrefutable evidence of the damage of load shedding when it comes to the right of access to healthcare, and also the right not to be denied emergency healthcare. And in fact, in this case, it is not merely a question of denial or delayed access. It is a question of complete deprivation of health. Why this is important is that 80% of South Africans rely on public health facilities. And it is also important when one looks at the defense taken by the president, who says, I have no legal obligation. You must go and ask the municipalities. The point we make here is that if 80% of South Africans are reliant on public clinics and public hospitals, and for those hospitals and clinics to function, they need electricity, where is the legal obligation? Is it truly, can this court truly say that the legal obligation is that of municipalities? Or should this court grapple with the problem and allocate responsibility where it vests, which is on the national government? So we say, in summary, on the health, load shedding has caused avoidable deaths. When we say it has produced a humanitarian crisis, we are not exaggerating, we are telling the truth. But load shedding goes beyond the parameters of a hospital. It also has an impact on education. This is dealt with in the founding affidavit, FO226. What we say here is that if you are a black student, and I'm not using race, probably I'm using class, but if you are a poor student in a township school or a village school and the electricity goes off, you must go home. The school closes. And that's because the schools still rely on the apartheid infrastructure, and there is no natural light in their classrooms. When you examine the impact of that in the light of South Africa's history of inequality in education provision and the recent effects, the devastating effects of COVID, and you take into account that on the statistics available in the country, where 78% of grade 4 learners, and those are primarily black learners, cannot read for basic meaning in any language. They cannot count, and that makes them functionally illiterate. So load shedding is not a question of just electricity going off at a given point in time. What it is doing, it is consigning a generation of black children to a life of no future. They simply are unable to be trained so that they can enter the job market. Load shedding also impacts psychologically on the growing children, with instances of load shedding accounting for 42% of South African children experiencing bullying. You will see this at paragraph 73. We've also shown that even where a school is open, in other words, they don't close the school and ask the children to go, the safety of the children and the teachers is compromised because the electricity generated water pumps cannot be relied upon. So in summary, on education, we say what load shedding has done is that it has created a scenario in which black children are falling even further behind their peers, particularly those who go to wealthier and dare I say, white schools who can afford to look after themselves in instances of load shedding. So we say this scenario puts a disgrace to the right to education, which is a fundamental pillar of our constitutional architecture. The third area which is impacted is safety and security. When load shedding switches off power at a police station in a country with such a devastating rate of crime, it disables the ability of the police to look after all of us. That should be pretty obvious, that a police station would have to be closed because there is no electricity. The fourth area has been water. We have shown that there is a clear connection between electricity availability and water availability. That is because the water pumping systems depend on electricity to operate. And that is why many municipalities, including the mayor of the city of Cape Town, has stated publicly that the most profound effect of load shedding is a major stress that it places on infrastructure, including the water infrastructure. The fifth area has been what we have generally referred to as small businesses. Now, we are not trying to discriminate between the different categories of businesses. We are trying to make a simple point that large industries, mines, even private hospitals, are able to put up backup systems and look after themselves. But small and medium enterprises simply cannot do so. And this fact has been acknowledged by the government itself. And you will see, we cite the express acknowledgement of the devastation that has been brought into that sector by load shedding at FA 363. And the last part has been electronic communications network. Now, you would have seen, Justice Davis, that in the answering affidavit.
Well, I suppose you mean the whole bench would have seen.
Yes, I don't think he's acknowledging us at all.
Yeah, I'm simply saying that as the presiding justice, but I accept the court would have seen.
I think let's stick to the court then. Yes.
You would have seen, my lord and my lords and my lady, from the founding papers, that there is a rebuttal on the electronic communications networks, which basically says the issue is vague and it's not fully set out. But it shouldn't be vague because of what we set out at FA 365, 0365 to 72, which is a report by Dr. Tabile Oga, who explains the impact of load shedding on the electronic communications network, who says the telecommunications sector is probably one of the most directly affected sectors from an operational point of view. From stage 4 onwards, telecommunication batteries cannot fully recharge, resulting in a loss of connectivity. Mobile companies are now compelled to install generators and alternative power supplies at the tower sites to mitigate against decline in battery loss. Mobile companies are spending 2 billion rands on batteries alone. But why this is crucial is what she sets out at 65 to 72, which says the consequence of this is that it affects the productivity of business, households, and students, and it thus harms economic growth. But the impact also is on national security. everyone knows that cell phone connectivity simply does not work during load shedding. So these are the 6 specific areas in which load shedding affects the rights that are contained in the Bill of Rights. But there is an overall economic impact of load shedding. And even this is summarized by Dr. Tabile Oka. This is what she says, and it's crucial when I deal with remedy. 1 hour of stage 6 load shedding costs the economy 500 million. 1 day of stage 6 load shedding costs the economy 4 billion rands. And according to the CSIR report published in 2020, it said that 10 years of load shedding up to 2019 had cost the economy 338 billion rands. And so when one factors the load shedding between 2020 and 2022, that number dramatically increases to 1.2 trillion rands, and which does not include 2023. And 2023 has actually seen the most steep examples of load shedding than all of the other years put together. And what does that mean? 1.2 trillion is equivalent to 1/4 of the entire country's GDP. And this far exceeds the budget allocated to police, to the courts, to prisons, to science and innovation. So that should put paid to any issue regarding rights that are impacted by load shedding and the devastation that load shedding has. Now, of course, my lords and my lady, this is not the case to end load shedding, today's case. The case to end load shedding is coming in Part B. This is a case for limited relief to mitigate the impact of load shedding, whilst we all work out whether or not it will be possible for the court to end load shedding through legal means, or whether it will not be possible. So it's necessary to always keep that distinction in mind. We're not asking you today to end load shedding. We're asking you today to exempt the most critical sectors that we have set out. You would also have noted, Justices, that the government, although it does not plead the state of national disaster that it has declared, it argues, by reference to the regulations, that certain sectors will be exempt. We obviously welcome that. But what it does show is that the hysteria that has characterized the argument by Eskom of a permanent blackout is not shared by the national government as a result of exempting certain sectors, because the national government itself is contemplating exempting certain sectors. Health is one of them, education is another, security is another, the judicial function is another.
There is something, though, Mr. Ngukaitobi, between putting something on paper to say, look, in terms of a regulation, you can, as a disaster measure, exempt certain subjects, say such as schools or hospitals. But putting it on paper does not necessarily transcend the factual situation of embeddedness. So no, I hear what you say, the government is contemplating it. Whether it's possible is still an open question on the evidence so far that we have.
So I accept, Justice Davis. One must always remember when we are debating this point about embeddedness, one must remember that the applicants are not wedded to exemptions at the instance of Eskom. What the applicants are asking for from this bench is that there should be uninterrupted supply of energy in the specific sectors. That can be achieved in one of two ways. The one is the reconfiguration of the grid, which is what our expert says, and in fact, which is what Eskom's own experts admit is possible. The only issue they say is that it's undermined by time and cost, but not by technical inoperability. So that's one. But there is a second issue, which again gets lost in the debate, but I would like to flag it as a central focus of this bench's examination, which is the alternative sources of energy. For a child who is a recipient of education, what matters is whether the switch is on or off, whether the light is on or off. It doesn't matter that at the back end, there has been a reconfiguration of the grid, or at the back end, there is a generator. What is truly inexcusable in this case, Justice Davis, I have to address you specifically because it was your question, not because I don't see your colleagues. What is truly inexcusable, Justice Davis, in this case, is that there is no explanation why the alternative sources cannot be made available. So if the government says we are going to exempt, it can achieve the exemption either by instructing Eskom as its parastatal to reconfigure the grid and to do it quicker than it says it wants to, or from that perspective, we are not fixated on a particular direction, or it can put generators, it can put alternative sources, solar panels, so many ways of ensuring the continued supply. A hospital such as Baragwana may well need generators. In fact, if you look at the evidence that has been, it's not Mr. Conrad, it's, I'll check now the name of the expert witness from Eskom, who says it is generally expected under the codes that, Dr. Minar, yes, who says it is generally expected under the code that this critical infrastructure must have a backup system. That's Eskom's own evidence. But we know, as a matter of fact, that they don't. If I may proceed then to item number 2 of what I want to address the court on, which is where do we allocate responsibility? And that is where a lot of the note that came yesterday says we've got some of the facts wrong and that they didn't say the things that we ascribe to them. Which is, how did we get to where we are? And again, I want to be short here because a lot of it is not in dispute. But let me be clear. We say that both the national government and Eskom have caused load shedding. We say that both could have avoided it. We say that load shedding is not an act of God. It was caused by Eskom. It was caused by the national government. This country once had reliable, stable, and largely universalized access to electricity. And here we are not talking about the days of apartheid. Apartheid, of course, had racialized access to electricity. But, my lords and my lady, by 2006, this government had achieved the goal of universal access to electricity. It had democratized access to electricity. And this is how it had interpreted the Constitution. It had interpreted the Constitution on the basis that there should be universal access to electricity in order to meet the goal of human dignity, which is in the Constitution. It's its own white paper that said without electricity, there is no dignified life. So we say that it is the same government that betrayed its own commitment to the Constitution. And we are not dealing in this case with a government that has been slow in the realization of rights like land, housing, access to water, which we know from all of the judgments that even there they have failed. But we are dealing with regression. We once had access, it was taken away. And this is despite the fact that the actual demand for electricity has not increased since 2006, when we had universal access to electricity. And this taking away was not some external force. This is not like COVID. It was the government itself that took away the electricity. The question then is a simple one, is how did it happen that the government caused such a regression? And it is, again, not difficult to understand how this happened, because we have the evidence of Mr. De Ruyter, who is the immediate past CEO of Eskom. When we start from the white paper, because Mr. De Ruyter says, in 1999, the national government knew that the country would run out of the surplus electricity by 2007. Says they knew as early as 1999. The reason they knew is because this is all contained in the white paper. And the white paper said normal life would be impossible without energy. And then it says in part 3 that Eskom's present generation capacity surplus would be fully utilized by 2007. And that is why the paper then stated that timely steps will have to be taken to ensure that demand does not exceed the available supply capacity, and that appropriate strategies, including those with long lead times, are implemented in time. We know that the cause of load shedding is that demand exceeds supply, but that is not something we suddenly came to know this year. It is something that was known by the government in 1999. And my lords and my lady, we also need to be clear here. This is the same government. It bears the same responsibility that it bore in 1999. So if they were responsible and they had the knowledge 2 decades ago, when they knew that they had to do enough generation to cater for the current needs. What Mr. De Ruyter also says is that right now, and he says this in paragraph 40 and 44 of his answering affidavit, he says, right now, if you want me as the CEO of Eskom to end load shedding, any CEO of Eskom, whether it's De Ruyter or someone else, Mr. De Ruyter or someone else, if you want them to end load shedding now, they need 2 things. One, they need to increase available generation of electricity by anything between 4,000 megawatts and 6,000 megawatts, 4,000 and 6,000 megawatts. And then they need to increase the energy availability factor. We've said in our papers to 75%, Mr. De Ruyter says 70%. But either way, Mr. Conrad says 70%. But either way, the fact of the matter is that if you look at the one pillar, the one critical pillar of load shedding, which is capacity of available electricity, capacity, the party that is at fault is the government. Now,
Mr. Ngai told me it's not that the government has sat back with folded arms and done absolutely nothing, not so.
No, it has in relation to generation capacity. It has actually sat back, folded arms, done nothing.
So they've not taken steps to put up further power stations.
No, they did, and I'm going to deal with that now, because in relation to the white paper, relation to the goals that were set out in the white paper, they actually sat back and did nothing. And I don't say that. It's Mr. De Ruyter, it's Eskom that says, what you did, Justice Collins, it's actually one of those points that are really strange about this case. Because we have the clear evidence of Mr. De Ruyter who says, 1999, you know that you must produce enough electricity so that when you run out of surplus electricity, you have no crisis. And what they also do at that point, they also take away the regulatory power from Eskom. They give it to themselves. And that regulatory power is taken not just in a policy, it's also taken in the Electricity Regulation Act. It's given to the Minister of Minerals and Energy. Under Section 34(1) of the Act, only the government can authorize the generation of electricity. They have the power, they've taken it away from Eskom. But as Mr. Director points out, they don't actually commission the new stations. They don't commission the new stations at all.
Prior to 2007, but beyond 2007?
You know, in the corrected, and because we initially said the commissioning was in 2007, they've now submitted a note in which they correct us. And let me just explain what they say. They say, so Eskom says Medupi and Kusile were not commissioned in 2007, as we say, but the tender with Hitachi to construct the boilers was concluded in 2007. According to Eskom, the first unit for Medupi was only commissioned in 2015. That's the note that they submitted yesterday. The first unit for Medupi was only commissioned in 2015, and the last one in 2022. The first unit for Kusile was commissioned in 2017 and is still not complete.
Yeah, that's what I'm saying. In terms of the white paper, they've not taken steps up until 2007, where the electricity supply would have run out. But beyond 2007, because we're now in 2023, have they not taken any steps?
No, we deny that the steps that they've taken are constitutionally compliant, because it's not a question of whether they have produced a piece of paper. They have produced many pieces of paper. It is whether or not the steps that they have taken are compliant with the Constitution. The point I was making in response to your question, Justice Collis, is that if you take the fact that it is known in 1999 that we are going to run out of electricity, and these units are not commissioned on their version, but a contract is signed in 2007 with Hitachi, and the commissioning on Eskom's version only starts in 2015, then we are justified in saying they've done nothing. Now, that does not mean that they didn't go to the office. It simply means that whatever they did simply has no prospect of meeting the constitutional requirement. By 1999, they had a constitutional duty to ensure that we don't run out of electricity. They acknowledged this themselves in the white paper. And we are also entitled to criticize them for commissioning the first unit for Medupi only in 2015 and the last one in 2022. We are also entitled to criticize them for commissioning the first unit for Kusile in 2017, and for pointing out that even though it was commissioned in 2017, it is still not complete. We also know, not from the evidence of Mr. Tereta alludes to corruption in his evidence here, but we know from the television interview that he gave that the appointment of Hitachi was beset by corruption. Why? Because the tender, according to him, was manipulated to favor Hitachi. And we also know that that corruption, according to him, has resulted in load shedding. So they manipulated the tender, it was corrupt, and we know from not from the interview, but from the evidence. We also know from the evidence that the design was flawed. So they get the tender corruptly and they get the design wrong. Perhaps unsurprisingly. The question that we are asking this court to grapple with is in circumstances where the alarm bells go up as early as 1999, and the commissioning begins in 2015. The tender is awarded corruptly in 2007. Can you honestly say that the government has discharged its constitutional obligations in those circumstances? Yes. Now, then I was dealing then with what Mr. Director says The other point the presiding judge asked me to deal with was the question about these inconsistencies about the payment of debt, etc. We accept what Eskom says. If Eskom says the money that it used, that it got, was not meant for maintenance, it was meant for something else, that's fine. We don't have that knowledge. This was the evidence given by our expert, Mr. Ted Bloom, that what they did, they prioritized the payment of debt. And we can see this from his own, it is Annexure TB6 and TB7. And I'll give you the actual references now, where that comes from. But again, we get to the point where you don't have to decide that question for purposes of today's argument. What is critical in my argument is that the government knows there is a problem of insufficient generation capacity as early as 1999. The question that I am asking the court to examine is whether the steps that it claims to have taken are steps that pass constitutional muster. Again, we know from the IRP of November 2013 that there was a specific reference to maintenance and generation. We know, according to Mr. Durator, that there was also inadequate attention to maintenance. And this is crucial because from the evidence of Mr. Conrad, there are two things you need in order to have a reliable supply of electricity. One, you need to increase energy availability factor to 70%. Two, you need new capacity at 4,000 to 6,000 megawatts. The question is whether the steps they have taken in relation to the energy availability factor are reasonable and constitutional steps, and the steps that they have taken in relation to new capacity are reasonable and constitutional steps. Mr. Durator says there has not been attention given to maintenance. It's explicit, he says so. So we charge the government that is responsible and Eskom that are responsible for both new capacity as well as energy availability factor with unconstitutional conduct. Now, there has also been another issue, and this is point number 4 under this subheading, that we say in our papers that the generation capacity improved when it was the era of the previous board and management, when they had adopted an aggressive maintenance strategy. And we say that on the evidence, the reserves increased by 23%, and that meant that there was no load shedding in 2016 and 2017. And Mr. Durator has criticized this on the basis that this is what is known as the keep the lights on at all costs. And that is where he says Mr. Matela Koko and Mr. Brian Molefe were working the power stations too hard and then not properly maintaining them. But again, the bench does not have to decide that issue. I'm simply acknowledging that it's one of the areas that we've been criticized for not correctly recording the evidence, but you don't have to decide that. What you do have to decide is a simple fact that right now, as we speak, the energy availability factor is at 56% right now. 3 years ago, it was at 69%. And again, this is not me speaking, it's Mr. Conradi himself who has explained this in his affidavit. You will see this at paragraph 15 of Mr. Conradi's affidavit. It says, we have had a gradual decline from 69% 3 years ago. Last year it was at 62%. Now it is at 56%. Now, if your target for energy availability is 70% and you're sitting at 56%, and these are the years of Mr. Durator. These are the years of Mr. Durator. These are not the years of Mr. Molefe, not the years of Mr. Koko. These are the years of Mr. Director, where we've had a decline in energy availability from 69% to 56%.
Listen, Gauteng, not to seem to favor any party, but the evidence, if there is a correction to say, well, yes, but they keep the lights on at all costs means that your EAF increases. It's the old argument which was mentioned by them before. If you run a car hard at 69%, of course you're going to attain higher speeds. But if you don't service the car and replace the parts, at some stage you will go down to 56% and you'll go down to so slow you might get closer to a standstill. But you say, you correctly, I think, say we need not decide that, but that is one of the consequences. If he is correct that the running too hard, or Conrad is correct that keeps the light on at all costs and running too hard, increase the percentage, you're still left with difficulties you now had.
That is true. Just sorry, I'm interrupting you.
No, so I hear what you say, but I don't see how percentages in the past can help us. We still need to deal with, was that correct? Or you say the blame is whatever you have done, whether you kept the lights on or whether you run too hard or did not run too hard, we are where we are now.
Yes, I say, Justice Davis, I say this, let me probably make this clear. I say that what we have on the evidence is that in the past 20 years, this government took its eyes off the constitutional ball. It didn't do its job under the Constitution. That is the problem. Even in the last 3 years under Mr. Director, it still did not do its job under the Constitution.
Yes.
That is the unavoidable conclusion on what I have been trying to say.
Whatever may have happened in 2016 or 2017.
Precisely. Yes. Now, this is probably where I should end the second. Perhaps I should end it with drawing these conclusions. And of course, the court knows that there is the evidence we put up, and again, we are criticized by our learned friends for this, of Mr. Pravin Gordhan and Mr. Makwana, the current chairman of the Eskom board. Mr. Gordhan says, the problem with Mr. Director is that he was chasing renewables at the expense of maintenance. Mr. Makwana says that Mr. Director also focused too much on renewables at the expense of maintenance.
But you say you couldn't care who of them blames each other. It's a collective responsibility of Eskom and its shareholder and regulatory authority.
Precisely, that's the point. Could I then move to topic number 3, which is where does the constitutional and legal obligation lie? The most important judgment on this score is the Vaal River judgment of the Constitutional Court. It is a recent judgment delivered on the 23rd of December 2022. It's called Eskom Holdings versus Vaal River Development Association, 2022 ZACC 44. Now, it produced a split judgment, but I'm relying on the majority judgment.
Well, that is what one generally calls the judgment.
Yes, indeed. I've seen there are some references in our learned friends' heads to the minority judgment. So let me deal firstly with paragraph 190, where Justice Madlanga clarifies the approach that must be followed by a court in a case like this. He says, at the outset, let me clarify that I make no holding on whether the residents have a constitutional right to the supply of electricity by Eskom. Now, you would have seen the president's affidavit is littered with this resistance. I do not find it necessary to make that holding because even though the residents did assert that right, they rely on several other constitutional rights, and those other rights are dispositive of the matter. So we ask this bench to adopt this approach. In other words, at this stage of interim relief, you don't have to find that there is a right to electricity. It is enough that there is a range of other rights, and that those rights, as Justice Madlanga says, are dispositive. And then he says at 191, at issue is whether, pending the finalization of the review proceedings that the residents intend instituting, this court must allow the effects of Eskom's conduct to persist. Must this court, at an interim stage, allow the residents to be subjected to such abject misery and horrendous violations of human rights? My colleague, Unterhalter AJ, whose judgment I had the pleasure of reading, says yes, I say no. Let me emphasize this. The question you have to answer, that we are asking the bench to answer today, is whether pending an application to end load shedding, which we are bringing in once we receive the record and have a chance to amend our papers. Pending that application, whether or not this bench should allow the clients I represent to be subjected to such abject misery and horrendous violations of their fundamental rights. The government says yes. We say no. The reason why the government says yes, and they may say that is an unfair characterization of their argument, is simply because if the government is to be taken seriously in its argument, it says this is not its job. It's the job of the municipality. Eskom, on the other hand, says we need additional capacity. It's outside of our control. It's in the control of Minister Mandashe. I'll tell the court shortly where that debate ends, what Mr. Mandashe says and what the president says in relation to one of the two critical areas that are needed by Mr. Conradi and Mr. Derrida to end load shedding. So that is why we say the effect of the government's argument that it is not their responsibility to exempt the sectors we have dealt with is that they must accept the consequences of load shedding that I have described until some other date that no one knows. Now, he also says, which is now at paragraph 207, because the court would have seen that there is an argument made about the probability of a collapse of the grid. But Justice Madlanga says the following. He says, all that my judgment does is to say Eskom is perfectly entitled to avert any ominous grid collapse it perceives. And then he continues, but because ours is a constitutional state, Eskom must do so in accordance with the Constitution and the law. It is neither above the law nor a law unto itself. Now, why is this absolutely crucial? The Constitution is not suspended during load shedding. The problem that I have tried to illustrate to this court is that if load shedding is an inevitable fact of life, as the government tries to make us believe, the question is, what does the Constitution require the government to do during load shedding? Does it countenance a scenario in which it applies load shedding on an indiscriminate basis without regard to the evidence of Professor Mativa, without regard to the impact it is having on poor children, without regard to the impact it is having on the skyrocketing rate of crime. We ask the court to apply the Constitution fully cognizant of the fact that load shedding on the government's version is an inevitable fact of life. It will be with us at least until 2025 on our calculations, because the best we hear from the president is that there is an extra capacity of some 2,000 megawatts, 2,160 megawatts that are coming sometime in 2024. But we know that to be very insufficient because Mr. Director says, I need minimum 4,000 megawatts. So we know for a fact on the pleadings that load shedding will be with us for a very, very long time. What we are asking the court to do is, what is the constitutionally acceptable manner of addressing the critical sectors during load shedding? This is precisely what Justice Madlanga had to deal with. Of course, it was not load shedding in that case, it was load reduction. And load reduction because the municipalities had not paid Eskom what it was owed. But Justice Madlanga said the unavailability of electricity, howsoever arising, says howsoever arising, has the following impact on human rights. And it's my job as a judge to mitigate the horrendous consequences of unavailability of electricity on those that are most destitute and most vulnerable. So we say, therefore, from a constitutional point of view, you have some signal from Justice Madlanga's judgment that you don't shrug your shoulders when violations are not denied and when legal responsibility is clear. We say legal responsibility is clear. It's Eskom and the national government. You grapple with the problem and put interim solutions until either load shedding ends or until this court decides that load shedding must come to an end in a judgment that may be given in Part B. But there is no scope for doing nothing in the face of these violations, which is what you are urged upon by the government. The government says, we have a plan, wait for us to implement the plan. They have had this plan. We know the consequences. When we instituted these proceedings, this was in January, the condition, justices, when you look just at Baragwanath alone, which is one of the largest hospitals in this country, it's affected by load shedding. We say Baragwanath is affected by load shedding. We say so in the papers. Eskom says it should have been exempted. The government, on the other hand, produces evidence that it's not, the government says it should have been exempted. Eskom says it's actually not in the list of the exempted facilities. So they themselves, between Eskom and the government, cannot tell you whether Baragwanath is exempted or not exempted. But on the output side of the electricity value chain, where Professor Mativa stands, on the output side, she says, I have no electricity. And even on the government's own version, in this country, we have approximately 400 health facilities, 400 hospitals. On their own version, they're planning to exempt 76. What will happen to the rest? So that is why we say there is no scope for doing nothing in the face of such egregious violations. So that's the constitutional framework pertaining to Eskom. as decided by the Constitutional Court. But there is also the judgment of Cape Gate of this, I think it was this division actually, where this division found at Cape Gate at paragraphs 130 to 135. It says, it would be incongruous if the ultimate beneficiary of and payer of the electricity stream downwards did not have the right to enforce due performance by the initiating supplier of electricity of a public law duty owed by it to the conduit of the electricity and for the payment of it. So it would be incongruous if Professor Mativa, the UDM, Mr. Mnguni, could not come to court and enforce a claim for electricity as against Eskom.
Sorry, which paragraph do you read from that judgment?
130 to 135.
Thank you.
Thank you. So we then, moreover, state, so that's on the constitutional front, and we know that the basis of the Constitutional Court's judgment is Section 7.2 of the Constitution. But we also know that Eskom has specific statutory obligation as the NERSA license holder in terms of the Electricity Regulation Act. Because Eskom has is the exclusive licensee for generation, transmission, and distribution. And it has the powers and obligations of a licensee under Section 21 of that Act. And Section 21.5, that is also explicitly referred to in the Vaal River judgment, imposes a duty on Eskom not to reduce or terminate the supply of electricity to a customer, subject to 3 qualifications in that Act. We don't fall under any of those qualifications. We are dealing here with people that are paying for their electricity. They are interested in continued services. But the default position is that Eskom may not reduce or terminate the supply of electricity to a customer. So we say in the first instance, they've got constitutional obligations confirmed in Vaal River and confirmed in Cape Gate. They have constitutional obligations in Section 7.2, at the very least, to respect existing access to electricity. But they also have statutory obligation not to reduce or terminate the supply of electricity to a customer. In addition, it is not only Eskom that is a respondent in this case, it is also the Minister of Public Enterprises. The Minister of Public Enterprises is duty-bound to observe the provisions of Section 6.4 of the Eskom Conversion Act, which says that it must enter into a shareholder compact with Eskom. Now, that shareholder compact has got certain underlying principles that are set out in Section 6.5. 1, the developmental role of Eskom, and B, the promotion of universal access to and the provision of affordable electricity, taking into account the cost of electricity, financial sustainability, and the competitiveness of Eskom. So what is crucial under Section 6.5 of the Eskom Conversion Act is that when the minister concludes a shareholder compact with Eskom, they must take into account that Eskom has a developmental role. Now, that is important because Eskom is coming from an era in which there was electricity apartheid, and its obligation is to close that electricity apartheid by ensuring, which is B, the promotion of universal access to and affordable electricity. And that universal access is to people that previously did not have electricity. What it simply is incongruent, what is simply incongruent, is for Eskom and the minister to stop electricity, to terminate it. So we say statutorily, there is an obligation to ensure universal access to and not just universal access, but affordable electricity. Those are obligations on Eskom and the Minister of Public Enterprises in the Constitution, as well as in the Eskom Conversion Act. Moreover, there are obligations on the Minister of Mineral Resources and Energy. And this is very important because of what Mr. Director says is the problem. What we know under that act is that electricity ultimately comes to us as the consumers through three stages, which is generation, which is where electricity is produced. In this country, we know electricity primarily comes from coal power stations. Number 2, transmission. And number 3, distribution. But when it comes to generation, there is Section 34, which deals with new generation capacity, which specifically says, Section 34(1), the minister, which is the Minister of Mineral Resources and Energy, may determine that new generation capacity is needed. But why? And then it says, to ensure the continued uninterrupted supply of electricity. Now, I must answer that question that Justice Collis had pressed me on at the beginning. The point I was trying to make, Justice Collis, if I wasn't clear, is simple this. The power to generate electricity lies with the Minister of Minerals and Energy. It is not an empty power. It is a power to ensure the continued uninterrupted supply of electricity. The conditions for the possibility of an uninterrupted supply of electricity were known by the government in 1999. Right now, as we speak, and this will astonish many people, right now as we speak, there is no additional capacity that has been added to the grid. If you recall, in our heads of argument, we had alleged, based on the expert who is an employee of Eskom and therefore didn't want to get their identity known. And I see in the supplementary note there's a complaint about that as well. But we had said that there has been additional capacity added to the grid. The note that came yesterday from Eskom says there is no additional capacity that has been added to the grid. Despite everything we've known in the last, say, since 2007, despite everything we have known, there is still no additional capacity to the grid. And Mr. Director says, I need the 4,000 minimum in order to end load shedding. And where does that obligation lie? It lies with the Minister of Mineral Resources and Energy under Section 34, subsection 1, because he says determine new generation capacity to ensure the continued uninterrupted supply of electricity. So which means the underlying premise of the Act is that there should be uninterrupted supply of electricity, except if the conditions in Section 21, subsection 5 are met. And in Section 34, 1E, it says the minister may, in consultation with the regulator, that's NERSA, require that new generation capacity must be established through a tendering procedure which is fair, equitable, transparent, competitive, and cost-effective, and 2, provide for private sector participation. Now, we remember Mr. Director's words, and in fact, I should quote this because he says this at paragraph 44.1. I think I should quote what he says. He says, since 1998, there has been insufficient investment in new generation capacity, a responsibility vested in the Minister of Minerals and Energy. As a result, Eskom has had to operate with insufficient generation capacity. At present, therefore, and as Eskom has consistently and publicly explained, it requires 4,000 to 6,000 megawatts for additional generational capacity. It cannot obtain that additional capacity unless new capacity is unlocked. Eskom does not hold that key. That's in paragraph 44.1 of his answering affidavit. But he then emphasizes this at paragraph 159.5.2 of his answering affidavit, where he says, I have explained above that as early as 1998, it was realized that demand would exceed supply by 2007. I have also explained that the necessary investment in capacity was not made. It's not us saying that. He says 1998 to 2007, that investment was not made. And then he says this was not Eskom's fault, as Eskom has no power to approve that investment. And then he says in paragraph 61, a decision about the commissioning of new generation capacity should have been taken in 1999 at the latest to avert a generation capacity shortage in 2007. We assumed this meant that it was only taken in 2007. We now know from the supplementary note that it was only taken in 2015.
Well, no, I think the decision was taken in 2004. The implementation only in 2016. Wasn't that the correction? Yes,
indeed. No, I'm talking about the commissioning, because that was
the commissioning, yes. But the decision which you say should have been taken in 1999 and thought to be been taken in 2007 was actually the decision taken in 2004 and the award to Hitachi in 2007 and then commissioning in 2015 and partially in 2017.
Yes, let me just check, because I've got the Eskom supplementary note.
Yes, I'm reading from paragraphs 9.1 and 9.2 therefrom.
Yes, precisely. So the point I'm making here is that in reference to Mr. Derrita's point about commissioning, I mean, we know that the commissioning itself is 2015, because we had said the commissioning was 2007, but they say that's wrong, it's 2015.
That in your argument, that makes it worse for them.
Yes, precisely. That's the point I'm making. And then he also says, in 2007, October, Hitachi Limited, a Tokyo-based conglomerate, was awarded the tender to construct both the Medupi and Kusile boilers, which is at paragraph 64. And then he says Medupi and Kusile have been plagued by a litany of design and construction failures, which have delayed their completion and negatively affected their performance, which is what he says at paragraph 65. But what's important about what Mr. Derrita says here, he says, we have said this publicly. We're not saying it for the first time in these papers. We've said this publicly and consistently. So in other words, Minister Mantashe is aware of it. President Ramaphosa is aware of it. We've said this publicly. So when you then examine, because he says, I will end load shedding if you give me 4,000 additional megawatts, or substantially reduce it according to Mr. Conrad. So when you then look at Minister Mantashe's affidavit, now we have to do this exercise because it takes us back to section 34.1, whether there has been a prima facie violation of section 34.1 of the Electricity Regulation Act. When you then look at Minister Mantashe's affidavit in paragraph 13, he never actually pins his colors about whether he has produced additional generational capacity. He speaks about regulations that were passed, but we know those regulations were passed in 2011. And then he refers to the president's affidavit. He says the actual steps, you will find them in the president's affidavit. You then go to the president's affidavit to try and work out there.
So can you just cross-reference where is Mantashe's affidavit appearing? Because the manner in which the splittings have been uploaded, the annexes are not properly numbered.
My sister, I got it in 14-152. It starts.
It stops.
It starts 14-152. And the actual affidavit, apart from the heading, is 14-154. I, the undersigned Samson Gwede Mantashe, state under oath as follows.
Yeah. If you could just, when you present your argument, just cross-reference the page to the court. Thank you.
Thank you.
Perhaps Mr. Mukatobe, you referred to a paragraph in that affidavit I refer to. That is paragraph
31.
It's 13. So that is at 14-159.
14-159.
At paragraph 13.
Oh, at the bottom thereof.
At the bottom, yes.
I see. Thank you.
Yes. And then So you will see so that's why he refers to the regulations. But when you look at those regulations, these are 2011 regulations. And then he says, well, the actual steps that have been taken insofar as generation is concerned, you will find in the president's affidavit. Now we then go to the president's affidavit. So you will find this at 1453.
So before we jump there, you say it was 2011, but the paragraph goes on. It refers to amendments in 2016 and 2020. The objectives are, inter alia, the provision of implementation of an IPP program.
Yes.
And then he says the regulations, IPP does not hold a controlling interest to the state. He says intends to undertake the development or creation of new generation capacity pursuant to a determination made by the minister in terms of section 34(1) of the Act.
Yes.
So that's where he links the non-compliance that you allege against him to the regulations.
Yes. But again, I mean, the bottom line is that you are going to look in vain to find the answer to Mr. Derrita's complaint. I need 4,000 megawatts. Where are they coming? When are they coming? And that is why he ultimately says, read what the president says. So we then try and see, I think the president's affidavit is at 1414.
14-14.
14-14, yes. So I just want to make sure that I'm.
I have it at, yes. It starts 14-15, Matamela Cyril Ramaphosa.
Yes, indeed. Now there, the useful starting point is at paragraph 101, which is at 1453. So what he says there, he's talking about an announcement made. So he says at 101, 1453, he says, despite the significant progress in implementing the plan outlined above, the severity of load shedding has increased in recent months. This is due to a number of factors, including a further deterioration in plant performance. The collapse of a flue duct at Kusile has caused 3 units to be unavailable since October 2022, resulting in 2,160 megawatts of capacity to be offline. So the starting point is since 2022 October, you can deduct 2,160 megawatts that are offline. Now, we already have a crisis that we are short of 4,000 megawatts. We are told that 2,160 megawatts are offline since October 2022. And then the president deals with these bid windows 5 and 6. You will see that at paragraph 68, which is 1442.
Yes.
Yeah, so if you are at 1442 at paragraph 68, because what they said this new additional capacity that Mr. Derrita is talking about will come from bid windows 5 and 6. But what has actually happened to those bid windows? So Firstly, he says the Department of Mineral Resources and Energy has initiated several processes to procure new generation capacity, not least through the Risk Mitigation Independent Power Plant Producer Procurement Program and bid windows 5 and 6 of the Renewable Energy Independent Power Producer Procurement Program, as well as by issuing a ministerial determination in terms of Section 34 of the ERA for the procurement of 14,777 megawatts of new generation capacity from various sources. Now, again, we know nothing about when, how. We then finally get to some detail at paragraph 98 of the President's affidavit, which you will find at 14.51.
Yeah.
So when you are at 14.51, you finally get some detail about actual time frames. Now, what we know about, which is 98.4. So finally, we get to the actual capacity. It says 98.4 designated local content for solar panels has been reduced from 100% to 30% to alleviate constraints. The IPP Office, Eskom and National Treasury have signed project agreements for 19 projects for bid window 5, representing 1,800 megawatts of new capacity, and for 6 projects from bid window 6, representing 1,000 megawatts. These projects are expected to enter construction in the coming months. So if you added, bid window 5 will give us 1,800 megawatts. Bid window 6 will give us 1,000 megawatts. And then you're trying to work out when exactly will this happen. It will enter construction in the coming months. So when is it actually giving electricity? We don't have any such detail. But it's far below what is needed because it's still 1,800 and 1,000. But we need 4,000 minimum, according to Mr. Director. And we've got a crisis of Kusile where the flute duct has resulted in a loss of 2,160 megawatts. And then when you then look the last paragraph, which is 74.2 at 14.42, again, which is a real problem with this affidavit because the one paragraph says construction will start in the few coming months. That's construction. And then you get another paragraph that seems unrelated to it that says, actually, this, if you look at 1442 at 74.2, which is releasing bid window 5, which allowed for a further 2,600 megawatts of renewable energy capacity to be procured, which will be added to the grid from early 2024. So you have a problem because bid window 5, according to paragraph 98.4, is only going to give you 1,800 megawatts. But according to paragraph 74.2, it is going to give you 2,600 megawatts. And according to paragraph 98.4, construction, not addition to the grid, construction will begin in the next coming months. And then in paragraph 74.2, there will be addition to the grid from early 2024. So this is the point we make, is that you have such a level of opacity about what exactly are the plans of the government to meet Mr. Director's need for 4,000 megawatts. What is actually happening on the ground to meet that 4,000 megawatts? There is no reliable evidence that there will be the 4,000 megawatts that is needed in order to substantially curtail load shedding. Yes. And as my colleague reminds me, is that what we know is that as a matter of fact, nothing has been added to the grid since 2018. That's in fact, according to Mr. In fact, it's in the President's affidavit at paragraph 14.41. Sorry, page 14.41, paragraph 74.1, which says, prior to the announcement of this plan, I had overseen a range of actions to address load shedding and achieve energy security. These include 74.1, reviving the renewable energy procurement program, concluding agreements with selected bidders for more than 2,000 megawatts from bid window 4, which had been on hold since 2018. So that's the full story on the most critical element to end load shedding, which is new capacity. We have Eskom saying it's Minister Mantashe's fault. You have Minister Mantashe not giving you any coherent answer, saying, read the president's affidavit. You go to the president's affidavit, you are left none the wiser. I want to then move to the second most crucial element, which is the improvement of the energy availability factor, which is the second part that we need in order to reduce load shedding. But I see that it's 11:30, so I wonder whether the bench doesn't want to take time.
Are you now going to move on to item 4 and then 5, the primary relief and the alternate relief?
Yes, I'll just spend 5 minutes on the second element, which is energy availability and maintenance. But thereafter, the big topics will be the just and equitable relief, indeed.
Right. I don't know, my colleagues, do you want to take an adjournment?
I think so. 15 minutes should be fine.
All right, so now I see it's 11:31. Let's reconvene at 11:45.
Thank you.
Thank you, Mr. Ngwatobi.
Thank you, Madam.
Thank you, my sister, my brother. Mr. Mukatobi.
Thank you, my lord. Let me finalize the debate on where the legal obligations fall. I have spoken about section 34(1) and the prima facie case we make that based on Mr. Derrita's evidence, it's quite plain that there has been a prima facie violation of the obligation to ensure sufficient generational capacity. The same applies to the second leg of the reasons for load shedding, which is lack of maintenance. You would have seen also in the note yesterday that Eskom actually concedes that there was inadequate maintenance. In fact, Your Lordship and I had this debate earlier. I don't want to waste your time, but the most important allegations you will find in Mr. Conradi's affidavit at paragraphs 10 and 11, which is at 13648. That is where he says the energy availability factor is standing at 56%. And when you trace it from 2019, it was at 69%. So there has been a noticeable decline. And what is needed is that the energy availability factor, which can only be improved through maintenance, should be at 70%. And it's also common cause that it has actually worsened under Mr. Derrita's tenure. The jury is out, as they say in the supplementary note, about whether he is to blame for that or not. We say that it's Mr. Derrita is to blame. And we also say that he took his eyes off the ball because in his own interview, which you will find at 20 between the pages of 65 and 66, where he says Eskom cannot be fixed. It cannot be returned to its former glory, in his own words. And he says there is a possibility that Eskom would morph into a transmission and distribution company. Although, as the note correctly observes, he also does say that one should not create a false alarm that there is an attack of coal, because Eskom will be in the generation business for a long period of time. But that is where we factor in the evidence of both Mr. Makwana and Mr. Godan, which Mr. Makwana says you were biased towards renewables. Mr. Godan says you were chasing renewables at the expense of maintenance. Now, we should not be misunderstood. Let me make the point clear. It is not the applicant's concern to choose for the government a policy, whether their policy is to pursue renewables or whether their policy is to pursue coal-based generation of electricity. That is not what the case is. The point of the matter is this: if you have heavy dependence on coal, like we do, all of our power stations that are supplying more than 90% of our energy needs are coal-based, you cannot replace them without putting in place an alternative. And what has happened is that the coal-based power stations are not performing, but there are no alternatives. So it is not a policy debate between us and them. It is a practical outcome, because for the clinics and the hospitals and the schools and the police stations, whether their electricity comes from the sun or from the wind, what's important is that it should not be interrupted. And there is an obligation to ensure that it is not interrupted. The last act that is relevant here is the National Energy Act 34 of 2008. It also, like the Energy Regulation Act, imposes obligations on the Minister for Minerals and Energy. In section 5(1) of that act, it says that the minister must adopt measures that provide for the universal access to appropriate forms of energy or energy services for all the people of the Republic at affordable prices. Now, unlike the Electricity Regulation Act, the National Energy Act goes beyond electricity. It talks about energy. Could be any form of energy, could be gas, anything. But the obligation is that there should be measures taken to ensure universal access to appropriate forms of energy. And in section 5.2, Roman figure 1, it says that the measures that are referred to in section 5.1 must take into account the state's commitment to provide free basic electricity to poor households. So there is already a statutorily inscribed commitment. It is not just in a manifesto of the ANC or in a white paper. It's in the Act that there is a commitment to provide free basic electricity to poor households. So, and then you also have section of the same Act, section 6.1 and section 6.2, which now deals with the obligation to develop integrated energy plans. And section 6.2 says that the integrated energy plan must deal with issues relating to the supply, transformation, transport, storage of, and demand for energy in a way that accounts for A, security of supply, D, universal accessibility, and free basic electricity, E, social equity, F, employment, and G, environment. So this act is crucial because it tells us that the fixation on electricity should not detain us as a matter of law, because there is a self-standing obligation to ensure universal access to appropriate forms of energy. And it must be read together with the Energy Regulation Act that specifically says there should be an uninterrupted supply of electricity. So whether you look at this through the narrow prism of fixing the power stations so that they produce electricity, or you look at it broadly as a question of energy sources, any energy source, the fact of the matter is that the constitutional commitment to universal access to energy has been inscribed into law, and those obligations have been imposed on the Minister of Minerals and Energy. Under the Eskom Conversion Act, those obligations have been put on the Minister of Public Enterprises through the mechanism of the shareholder compact. They have been put on Eskom. And under Section 7.2 of the Constitution, those are also imposed on all organs of state, including Eskom. So anywhere you look, universal access to energy is a central pillar. It's indeed the organizing principle. And so is the provision of free basic electricity to poor households. That too is an organizing principle. And the duties are cast throughout the national government under Section 7.2 of the Constitution and under specific statutory instruments. And indeed, the president himself is under a duty to ensure that the government departments function cohesively, not in isolation, that they meet the obligations that are contained, the executive obligations contained in statute, and that they do so in a coordinated fashion. Under Section 83 of the Constitution, the president is duty-bound to ensure that the provisions of the Constitution are fulfilled. That is his primary obligation, is to ensure that the Constitution is fulfilled. We know this from the Ngandla judgment, that the office of the president's primary obligation is the implementation of the Constitution. And when he does so, he must ensure that the functions of the state departments are coordinated. Now, why do we say this? And I saw that there was something in the heads of argument of the president, something disturbing, which says that we want to attack the president. So it seems that they want to defend him against us attacking him. and we are doing so irresponsibly. Now, the reason why I'm saying that's a bit disturbing is because nobody wants to attack President Ramaphosa. If it was President Zuma who's the president, we would have brought the same application. What we are concerned with is the office of the president and its dereliction of duty. And we say this because not on anything we have said. Mr. Derrida says, you have not given me generation capacity, which I need in order to end load shedding. I don't have enough money to devote or dedicate towards maintenance. Who is in control of both of those elements? Mr. Derrida tells us in relation to the first one, it's the Minister of Minerals and Energy. In relation to the second one, it's the Minister of Finance. Sure, the Minister of Finance is not a party, but the entire government of the Republic of South Africa is a party. So once you have a scenario, with the greatest respect, justices, once you have a scenario in which the head of a huge parastatal like Eskom, Mr. Derrida, the head of that parastatal, says, I don't hold the key towards the ingredient I need to end load shedding. It's held by someone in the cabinet, and I've not been given it, and I've said this thing publicly. The question that you've got to ask is who has the obligation to ensure that Mr. Derrida is given the key that he says he does not have? Under the Constitution, not politically, under the law, where does that obligation fall? And that is an obligation that we have had since 1999. The Constitution doesn't leave that question to chance, doesn't leave it hanging in the air. It imposes it squarely on the president. A, by requiring him to ensure that the obligations in the Constitution are fulfilled, and secondly, by specifically telling him that he must coordinate the functions of state departments and administrations, so that he cannot have a scenario, and one of the points that has been made here, so that he cannot have a scenario, justices, where Minister Mantashe says to the country, Eskom is trying to overthrow the ANC government through load shedding. It's in the papers, not denied. Why do we have a scenario in which a minister of state can publicly say that Eskom is trying to overthrow the state through load shedding? The Constitution, again, doesn't leave that to chance. It requires the president to ensure that state functions and state departments and administrators are coordinated in the way they discharge their obligations. So on a prima facie basis, it's quite plain to us, we say with the greatest of respect, that there has been a failure of a presidential duty, which is imposed by Section 85C, because there is plainly lack of coordination. We've read the answering affidavit of the president. What you will not find is an answer to the two critical issues that are in this case. One, Mr. Derrida says, I need additional capacity. I'm not being given by the Minister of Minerals and Energy, and I've said so publicly. Says, I don't hold that key, someone else holds that key. I need extra money, and I can only get it from Treasury. What you also will not find is an answer to this point where Minister Mantashe publicly stated that Eskom is trying to overthrow the state. How does it happen that Eskom, as an organ of state responsible to both Minister Mantashe and Minister Gauteng, can be accused publicly of trying to overthrow the state if there is coordination? And that is why we don't take this lightly when we suggest to the court that you have to find prima facie that there is also a failure of a duty imposed on the president to coordinate his cabinet and to coordinate the organs of state that report to those members of cabinet. So we say in summary, the constitutional and legal obligations are clear. They cannot be evaded and avoided. The attempts by the president to avoid and evade should be regarded as feeble and legally unsustainable. At the end of the day, they cannot assign this obligation to municipalities. We don't say municipalities have got no obligation to provide electricity, but we say, just like in Cape Gate and just like in Vaal River, we say you've got to locate municipalities properly in the value chain of the electricity provision system. Generation, which is the critical problem, is the national government's problem. Transmission is also a national government's problem. Distribution is shared between Eskom, municipalities, and other private users. But municipalities are consumers, they are customers of Eskom. If there is no generational capacity, there is no energy to go to municipalities. And so it's self-serving for the government to say go to municipalities when it knows that in violation of its own obligations, it has not ensured that there is enough electricity to go to municipalities so that they can consume and distribute the balance and then take their money and give Eskom whatever is left. Because that's how the value chain works. You get electricity from Eskom, you use some of it, you give others to residents. The residents pay you, you take your money or your margin, and then the balance goes to Eskom. But you can never avoid the obligation that it is the national government that is responsible for the provision of electricity, including to municipalities. So on a prima facie basis, we would suggest, with the greatest of respect, that there are obligations imposed in law on all of the respondents. And we don't ask you for the purposes of the determination of whether a prima facie right has been established to distinguish between which respondent, but I have shown that specifically each respondent is assigned a duty under a specific statute and overall under the Constitution. That then takes me to the question of what should the court do if it is with me that there is a violation, there is a prima facie right, and these obligations fall under law, under the various departments. It seems to us clear that the harm that we have shown is irreparable. The harm is irreparable. You could arguably say that any lost school time can be recovered. But once you aggregate what we are dealing with, which is we have been having the same problem for the last 10 years, you can see why the harm to township children and rural children attending school is not in fact repairable. The same way as the harm that is caused to patients and that is caused to people that work in health facilities. Same way as, if you've looked at the stories that have been told by people that run small and medium enterprises, they've had to shut them down. That harm too is not repairable. If you look at the impact of not having access to security services because the police stations cannot operate during the hours of load shedding. And sometimes load shedding can go on for 10 hours. That harm too is just not repairable. And so is the economic cost that has been calculated so eloquently by Dr. Tabileog. That harm too is not repairable. So we are engaged in probably one of the most important human rights stories because of lack of capacity of the government to discharge its constitutional mandate. The question is, what is the remedy? What do we ask the court to do with it? Let me start with the alternative remedy, which is in paragraph 5. I'm going to deal after this with the primary remedy. Let me start with this alternative remedy. What you find in terms of the defense to the alternative remedy, and I've dealt already with the issue about it's not our responsibility, it is somebody else's responsibility, and why you should reject that notion because of the interlocking statutory provisions that I will that have been set out. And the primary respondent is, of course, the state. It's the government that owes us these rights. They are the primary respondent. What do they say? What does the government say in relation to the alternative remedy, paragraph 5? And how will this alternative remedy actually work? It seems to us quite plain. If you are in a court building and there is load shedding, they put up a generator so that there is seamless transition. The question is whether they should also be instructed that they should make alternative sources available to every hospital, every school, every police station. And they should figure out a mechanism to assist small and medium enterprises insofar as the consequences that are caused to their businesses are attributable to load shedding. And the same thing as trying to exclude or support telecommunication services. Question is, what should they do? So it seems to us the answer to the fundamental problem of grid embeddedness and all of those issues is alternative sources of supply. What does the government say about that? What we see in the answering affidavit by the president at paragraph 49 is that he says that it's not the function of the Department of Public Enterprises to procure energy sources for any of the establishments listed in paragraph 3 of the applicant's notice of motion. And then they say that the applicants have not identified the legal basis on which the Department of Public Enterprises should be burdened with the function. Then they also say the Department of Public Enterprises is not responsible for such operators, and no case has been made to suggest that their right promised in section 22 of the Constitution requires the DPE to provide them with alternative sources of energy where there is load shedding. Now, this is the small and medium enterprises. But even then, this relief will open floodgates of opportunistic applications in circumstances where it will be impossible for the DPE to comply therewith. And then they say that there is no basis to procure alternative sources of electricity in relation to facilities that fall within the sphere of municipalities. Let's start with the first issue, which is it's not the problem of the Department of Public Enterprises to procure alternative sources for the specific sectors. We have cited the president and the entire government of the Republic of South Africa, cited them as a respondent. We did that purposely because we anticipated that this ping pong, blame shifting, it's not my problem, it's someone else's problem, is inevitable in a case like this. Because even prior to the institution of these proceedings, there were already signals that Minister Mantashe says it's Eskom's problem, Eskom says it's Minister Mantashe's problem, and someone else says it's Minister Godhan's problem. The question for the court is not which specific department. The question is whether it is the responsibility of the government of the Republic of South Africa in circumstances where the clinics have no facilities to ensure that they do. That obligation arises primarily from two sources. The one is it arises from the specific section 27 in the Constitution. It also arises from section 7, subsection 2 of the Constitution. And it is the obligation to respect and the obligation to fulfill the rights that are contained in the Bill of Rights. Now,
Mr. Nkatu, if I might interrupt you at this stage. I understand what you say, that if you can't give electricity via Eskom, give at least an alternative source of electricity or energy. I'm reading from paragraph 5 of the amended notice of motion.
Yes.
And this is now Eskom and the minister must take immediate steps. Now, the formulation of that prayer and your fear of blame shifting are somewhat interlinked. Say, for example, prayer 5 is granted as it stands. Is it not too vague? I know you say you don't want to prescribe policy, and certainly a court can't prescribe policy because then the court would breach the line of separation of powers. But similarly, a court is obliged to give an order if it deems necessary to give a remedial action, which can be enforced, which can be implemented, and which can be reverted to if breached. So if paragraph 5 just says Eskom and the minister must take immediate steps to procure alternative sources, and the minister says, well, I will go to the Minister of Finance, I will see what funds he has in his new budget, and thereafter I will issue a tender for someone to determine how much generator power per hospital, per clinic is needed. And I'll do the same for all the schools and so on. And by the end of the year, I might issue a tender. And you will come and say, but you've breached your duties because children are left literally in the dark, as are patients. And then the minister might say, but I've taken immediate steps.
Yes, no, I accept that. I think there's scope to make it more refined by specifying the timing and the nature of the steps.
Without crossing the line of separation of powers.
No, you see, Justice Davis, on the issue of separation of powers, one must distinguish between two questions. The question is who decides the law. That's quite clear that the judges decide the law.
Yes.
The next question is who decide on an interim basis what is just and equitable. The answer to that is that judges decide what is just and equitable. So when it comes to remedial power, and even at interim stage, your powers are actually quite wide, because you would have determined on a prima facie basis that there are significant rights incursions. And you are then trying to work out what is a just and equitable interim holding position until we deal with Part B. And even there, you actually have quite wide powers to fashion a remedial action or fashion an appropriate order that would solve on an interim basis the challenge that we are bringing to the court. So we would submit that if you say you specify time, you specify the nature of the action, you are not prescribing to them that whatever is binding on them, like the PFMA, etc., must not be complied with. But what you cannot have an open-ended, and I think that's the caution you are bringing to me, actually, is we cannot have an open-ended order that will ultimately result in a brutum fulmen.
Yes.
Yes. No, I take that point. And that's why I argue that there is scope to refine it and make it more exact.
All right. Well, thank you. There was just a concern of mine on the relief as asked.
Then, if I may then look at so I've answered rebuttal 1, which is, why are you coming to us? Well, we are coming to you because you have obligations under the Eskom Conversion Act, you have obligation under the Constitution, you have obligations under the National Energy Act, and you have obligations under the Electricity Regulation Act. And it's crucial to look at the National Energy Act because it's not restrictive about what energy sources. It says the energy sources must be there, and it's also crucial to look at the Electricity Regulation Act because it guarantees uninterrupted supply, except in the conditions set out in Section 21(5). So we know here that it's not just, temporary interruptions. Some of these interruptions could be for the whole day. So that's why we're coming to them. But we say it doesn't matter for our purposes because you've got to make the order that is binding on the president and his government because the president and the entire government are before you. And we will come back with a contempt application if it is not complied with. Then rebuttal 2 says that the DPE is not responsible for such operators, and no case has been made to suggest that their right promised in Section 22 of the Constitution requires DPE to provide them with alternative sources of energy when there is load shedding. Now, here we are dealing with small and medium enterprises. It's extremely difficult to understand why they can say with a straight face that no case is made about why small and medium enterprises should be dependent on the government. Because this was the evidence given by the minister herself, the Minister of Small Businesses. And you will see this at F0363, who said, SMMEs are particularly hard hit by continued power outages. Since many cannot afford alternative power sources, such as generators, they are forced to pause trading during load shedding. The minister understands that some small businesses resort to selling perishable goods, such as meat and vegetable, at low prices to avoid them rotting away. It goes without saying that this eats away on their much needed income. This sector was devastated and is still barely recovering from the ruinous effects of COVID-19. We cannot afford losing more businesses and jobs. Now you look at the applicants we act for, some of whom are owners of small businesses. They fall exactly in the same category that the minister spoke about. And you've got to always keep in mind that we once had universal access to electricity in this country. These small businesses once had access to electricity. It was taken away by the government. That is the problem. It was taken away by the government. We say when the government took it away, it had a constitutional obligation to ensure that there is no disruption in trade. If you say, I've got a problem because I have to maintain my power stations, you cannot simply shut down the power stations without considering the adverse consequences on small and medium enterprises. So one may say technically that it's not the Department of Minerals and Energy, it's not the Department of Public Enterprises. Those are cited because they have specific obligations insofar as the performance of Eskom is concerned, and Eskom is the main provider of electricity. But it is the responsibility of the government. And that responsibility has been publicly acknowledged by the member of the executive responsible for small and medium enterprises. But on the evidence, what we do know on the evidence, because that is what the founding affidavit sets out. On the evidence, what we do know is when we run out of electricity, we are forced to cease trading, which means we fire people, remove them. And sometimes we have to sell the meat that we are keeping in the fridges at non-competitive prices. Sometimes we have to sell the vegetables so that we can avoid them rotting away. So when you see a claim made that there is no basis on which to argue that Section 22 of the Constitution is violated, you always have to remember that this was an existing access to the right. An existing access to the right that was taken away. So we are not dealing with imposing a positive obligation on the government to do things that the Constitution promises. We are saying here that there has been a failure of the duty to respect that is in Section 7.2 of the Constitution. We are also saying it is unconstitutional to take regressive measures or measures that have a regressive and corrosive effect on the rights that are in the Bill of Rights. And so that is why it is open to the court to say that in relation to all small and medium enterprises that meet the definition in the Small Businesses Act, the government is under an obligation to provide them with alternative sources of energy. That leaves it to them to decide who should be, who falls within the definition of the Act, who falls outside the definition of the Act. But what you cannot have a scenario in which we are destroying livelihoods of people that depend on small and medium enterprises, in the same way as Eskom over time was systematically destroyed under the government. Then you have a further point that says this relief will open floodgates. If you granted the relief that says if you are a small and medium enterprise, you have a right to be supported by the government during the period of load shedding. They say that will open floodgates and opportunistic applications. It's unclear why. Unclear why that will open floodgates. because you either meet the definition in the Act or you don't meet the definition in the Act. So there's no basis to say do not give relief, because there will be opportunistic applications that will come.
In the CBG, and we are confident that we're going to ensure that Ramaphosa resigns.
Yeah, I'm not sure what that interruption was, Mr. Ngukatobi. All right, but you say it won't open floodgates, but it might open, well, not open gates, but it might involve a vast number of applicants.
Yes.
A vast number of those who qualify.
Yes. No, I accept that, indeed, Justice Davis. You know, let me make one.
Sorry, but for schools, you know how many schools there are.
Yes.
Hospitals, you mentioned the 400 at least. But in this category, there's, it might be it's currently an unknown number.
Indeed, we don't know, but we assume that there is a process by which you register to be a small and medium enterprises under the Small Businesses Act. And you either qualify or you don't qualify. The government should be allowed to decide for itself who qualifies and who doesn't qualify. But the principal point we are trying to make is simple this. The government itself has acknowledged the impact of load shedding on small businesses. And it is not the fault of small businesses that they are where they are. It is the fault of the government. And the government must solve that problem that it created by opening up a system in which people are given material support so that they can navigate their way in circumstances of load shedding. And this must happen because we have no way of knowing when load shedding would end. And I shown the court precisely what the government says in response to Mr. Derrita's public pleas that to end load shedding, I need 6,000 megawatts. And we have no way of knowing where those megawatts are, when are they coming. And Mr. Mantashe, who's responsible to open up those megawatts, is not actually committing on anything tangible.
Yes, I hear you. All right.
Now, then you have the municipality problem, that, and that goes into the water issue, that water providers falling under the municipalities. We should be asking the municipalities to do this. But we answered this right at the beginning, that you cannot say that you should go and ask a municipality in circumstances where we know that the central problem is the problem of absence of generation capacity, which is under the Electricity Regulation Act, a national competency. And there is an obligation here of cooperative governance that is specifically set out in the Constitution. So the mere fact that we say that the national government has an obligation does not mean that the court must now issue an order that says that municipalities are no longer responsible for the provision of water. But we say that insofar as the failure to provide water is linked to an electricity-based infrastructure, the solution is not a municipality solution. The solution is a national government solution. And we know this because on the evidence, we have the mayor of the city of Cape Town, who says that the most profound effect has been the impact of load shedding on infrastructure. The question is what should be happening now until Part B has been decided in relation to access to water? Should the court say, I'm sorry that you are losing all of your rights. I'm sorry that the Constitution is being violated. There's nothing I can do for you. And that's precisely what Justice Madlanga said. It's not countenance in the Constitution. The Bill of Rights is not suspended because of load shedding, especially because load shedding is not an act of God. Those defenses are then repeated in the heads of argument. You will see them at page 30, paragraph 6.2, paragraph 6.3, and then you get at page 33, paragraph 7.7 of the government's heads, which is separation of harms, separation of powers harm, so-called separation of powers harm. Now, I tried to provide an answer to this earlier, But let me recalibrate that answer. One, the court decides whether on a prima facie basis rights have been violated. That's number one. Number two, the court decides what is an appropriate remedy in order to address the prima facie violation of rights. Number three, when the court does so, it must obviously take into account that it must issue a remedy that is capable of enforcement, but a remedy, most importantly, that addresses the harm. It's no use saying there is a broad principle of separation of powers. The issue that has to be taken into account is what is the role of a court in circumstances where there is an egregious and manifest violation of rights. So say in those circumstances, one cannot resort to a generic statement about separation of powers when the power to decide prima facie violations, power to decide an appropriate interim remedy, and the power to do so, cognizant of the fact that the order must be capable of compliance, but also it must vindicate the rights. We know this from the Hoffman versus South African Airways judgment, which we have referred to in our heads of argument, that the most important element is that the remedy given must be must respond to the rights in issue. And my colleague, I think I can't remember if I did. I think I read this paragraph, but maybe I should read it again. It's paragraph 194 of the judgment by Justice Madlanga, where sort of similar, not the same, similar questions were raised, where he says the first judgment's propositions fails to take into account the fact that multiple rights protected in the Bill of Rights can be violated by a single action. And those rights are not always squarely or perfectly correlative or corresponding. What informs the need for their vindication is the fact of their violation. In the present matter, it is the sudden, substantial reduction of electricity that resulted in the rights violations. The logical corrective measure to address the rights violations is the reversal of the causative act. That is the restoration of the usual electricity supply. How else do you halt the rights violations? Do you do nothing and throw up your hands in complete despair whilst the violations continue unabated? If that were the case, the law would really be the proverbial ass. Now, that's not me saying that, it's the Constitutional Court. Now, so those are the three defenses put up by the government. There is an overall defense of cost and budget. Let me not avoid it, and let me address this point about, obviously, the remedy we're asking will cost money. It doesn't come for free. But the question for the court is, what does the Constitution require when it comes to decisions that have budgetary implications? Does the
Are you now talking about the alternative remedy?
No, yes, the alternative remedy. I mean, procurement of generators will all cost money. So, I mean, everything we've asked. Sorry.
No, yes, carry on.
Yes. So I'm saying everything we've asked for, whether it is the primary remedy or the alternative remedy, will cost money. There is no doubt about that. Now, what does the Constitution require in circumstances where the judge's orders would have implications on the budget? Does it say that the budget is a complete defense, that as soon as you say it's going to cost me 12 million rands, I haven't budgeted for it? Sorry, is that the end of the debate or not? We have set out various judgments from the Constitutional Court, and which deal with what the correct approach of a judge or of the courts ought to be in cases of budgetary defenses. The first one is the Treatment Action Campaign judgment, particularly at paragraph 99 of the Treatment Action Campaign judgment. Now, you remember that in Treatment Action Campaign, the issue was the rollout of the nevarapine, the AIDS-related drugs. And the government there quite early on, I think this is a 1999 judgment, even there said, no, we don't have the money. And the court says you simply have to find the resources to do so. Simply have to find the resources. And that's in paragraph 99. But importantly, where you say there are resource constraints, we've cited this from Rail Commuters Action Group case versus Transnet at paragraph 88, where the court says that the government must justify a failure to implement a constitutional right by reference to the precise character of the resource constraints, whether it is human or financial, in the context of the overall resourcing of the organ of state. So you cannot simply say, I cannot afford the 356 million rands that is needed either for the entire hospital sector to be provided with alternative sources of energy, or for the 76, because there is a conflict between what Eskom says and what the government says. One says it's actually 76, that means 356 million. The other says it's the entire sector. But either way, it's not an answer to just say, I don't have the money. You've got to explain what steps you are taking to obtain the money. And it's contradictory as well, Justices, because you have provided for a state of disaster in which you have provided the country with an expectation that you are going to do these exemptions. Where is the money to finance the state of disaster? So you could not have published the regulations under the state of disaster in which the very relief that we are asking for here, at least in part, is contemplated if you seriously did not have the resources to do so. Otherwise, it means that the state of disaster regulations are just published as a SOP.
Well, that might be it, but I recall them also having limitations to say, subject to available resources, subject to X, Y, and Z. They have an almost, apart from the SOP factor that you say, they almost have a saving mechanism in themselves to say, look, it's a state of disaster, but we can only do what we can, type of thing.
Yes, precisely. But that also shows why that's not an answer to the application, because it's self-controlled. And so we can make a promise, but we reserve the right not to fulfill it.
Yes.
Now, then we have referred to the Blue Moonlight judgment at paragraph 74, where the Constitutional Court, in the context of the right to housing, said it is not good enough for the state to say that it has not budgeted for something if it should indeed have planned and budgeted for it in the fulfillment of its obligations. So you can't come to court and say, I'm sorry, I haven't got the money, when in fact you should have ensured that there is budget available to fulfill the obligation. And we began this debate. I remember the discussion I had about 2 hours ago with Justice Collis about what precisely is the defense of the government. Do they say that we did nothing, or do they say we did something, but it's not enough? The fact is that if you took that debate seriously, you will get to this point, that this crisis we're having is entirely foreseeable. And if you have a government that is functioning according to its obligations under the Bill of Rights, it knows that I have a crisis of load shedding and it's an ongoing crisis. I'm trying to solve it. But that crisis has immediate implications for the Bill of Rights. And so there is an obligation to plan for the amelioration of the load shedding crisis on the Bill of Rights. That is why this case ultimately is about the human cost of load shedding. Does the government simply say, I'm sorry about the human cost of load shedding? There's nothing I can do about it. I haven't got the money. Is that the correct constitutional response? Yeah, I'm going to take it up now. Now, and then, so I've set out what the constitutional principles are. Then there are examples then of judgments where the courts overall have made decisions that have implications for the budget. And the most important in this is the Mazodzo judgment and the equal education judgment. In the Mazodzo judgment, paragraph 35, it refers to the Blue Moonlight judgment, and then it says in the middle of that paragraph, accordingly, the respondents have been well aware, and that is a case where the government fails to provide furniture. And these are cases where a school didn't have furniture before and is asking for new furniture. These are not cases where you once had furniture, it was taken away by the government. Just like here, where we once had electricity taken away by the government. But even in those cases of positive obligations, this is how the judges have resolved them. It says, accordingly, the respondents have been well aware for a considerable time that proactive steps need to be taken to address this shortage and to fulfill the right to basic education as required by Section 7 and 29 of the Constitution. In these circumstances, says the judges, it is not good enough to state that inadequate funds have been budgeted to meet the needs and that the respondents therefore cannot be placed on terms to deliver the identified needs of schools.
I think maybe someone else has joined the online platform who wasn't part of the housekeeping discussions this morning. I would request other parties except the judges and the council addressing the court to mute their microphones, please.
I think this hearing has been very popular in the light of the ongoing protest.
Yes, but let's call it a hearing and not a contributory conversation.
Yes.
We will listen to you, Mr. Ngwatobi.
Thank you, my lord. Then the judges continue to say,
Sorry, you are muted. I can't hear you. Council?
Yeah, sorry, I think, yes, I think it was paper that ended up on the muting signal. Sorry. So I'm still at paragraph 35 of Mazodzo, which says that it is not good enough to state that the full extent of the needs is unknown. And that goes into the issue of floodgates. We don't know how many. The court says the fact that you don't know how many, but you can work it out, is not an excuse. And then it says the information available to the respondents from 2011 was such that reasonable estimates of the funding required could be made and reasonable steps taken to plan for.
Sorry, you are muted again, Council.
Then I wonder what's. I apologize. I don't know why it's happened again because I've not touched my computer. Then you have the equal education case. I think Justice Davis, you are muted now.
Yes, thank you.
Yes, thank you. And then the equal education case is also an Eastern Cape judgment from Justice Plaskett when he was sitting as a judge in the Eastern Cape. And it's paragraph 194 and 196 that are relevant there. In paragraph 194, the judges say the obligation upon the respondent to provide basic education has been in existence since 1996 when the Constitution was born 22 years ago. Thus, the respondent has had adequate time to plan and budget for all its duties in respect of the right to basic education. Even accepting that apartheid left gaping disparities and a wide gap in education infrastructure, with the proviso in sub-regulation 45A, there is no hope that such a gap will ever be closed off, and if so, to what extent? The proviso provides the respondent with a lifetime indemnity against discharging the duty she owes in terms of section 29(1)A. Then in 196, they say our courts have always rejected the reliance on budgetary constraints as a justification for failure to provide essentials. And in relation to the first part of the case, which is the exemption relief, whether the primary exemption relief or the alternative exemption relief, we are asking for the essentials, the bare essentials. Keep the hospitals operational 24 hours a day. Keep the schools operational 10 hours a day. Keep the police stations open 24 hours a day because they close during load shedding. So that's what we are asking for. It's bare essentials. It's not the Rolls Royce of the human rights world. It's bare essentials that is being resisted by the government. So we say that insofar as the relief that you may grant, the alternative relief that you may grant, which we are asking for, insofar as it implicates the budget and insofar as the government has tried to put up budgetary excuses, you have enough ammunition from case law to show how budgetary defenses have to be dealt with from a constitutional point of view. The ultimate end point is that if you have constitutional obligations, they don't get suspended simply because of your own failure to provide enough budget for their fulfillment. So if buying more generators, buying more solar is going to cost money, so be it. You can never put a price on the Bill of Rights. That then takes me to the last of the submissions I have to make. So let me make this one point clear. If you are with us on the alternative remedy, you need not decide paragraph 4. If you are with us that you, you need not decide whether or not you should grant the exemption we seek in relation to Eskom, because it would be enough for my clients that they have an alternative source of energy, and therefore the harm that we are complaining about would have been averted. But Eskom still needs to be joined in that relief, because we don't know enough about what adjustments to the connectivity still need to be made by Eskom in order to accommodate whatever alternative sources. So we cannot have a scenario in which Eskom goes scot-free just because you have provided us with paragraph 5. It must be an order that binds the national government as well as Eskom. So if you are with us on that remedy, then you don't get into the technical arguments about the embeddedness, which is, I think, the most important argument that Eskom relies upon, because it says the system is so embedded, or the institutions who are seeking are so embedded, that excluding them would mean excluding a far greater number of people. And what that would mean is that it would undermine the reasons behind load shedding, because you would get...
Now, I understand that. Just on the question of practicality again of orders, if you are successful and if prayer 5 is granted, you say we need not consider 3 or 4. But if, for example, practically there is a reconfiguration of, let's call it Baragwanath as an example, then of course the need for 5, although it might have been ordered, will fall away.
Indeed. Indeed.
Because the wording is just an alternative source. So the alternative source is just dependent in the wording of the prayer if the primary source is unavailable.
Yes, indeed.
I see. Yes.
Now let me just get then to the primary relief. Now, so our understanding is that what cuts through the defense by Eskom is the embeddedness. I'm talking now about the technical. I've addressed the issue of money and time. But there is a technical argument about embeddedness. what they say is that the institutions are embedded, and the embeddedness means you cannot isolate one hospital, because isolating one hospital will mean isolating a greater number of people. Isolating a greater number of people would mean you are undermining the reason for load shedding, because you keep the lights on for a greater number of people. If you do that, the ultimate outcome is going to be load shedding for all, as opposed to, in fact, load shedding for all the time. And so you will be causing far greater harm than good with the relief that you are seeking. That's the sum total of the defense of Eskom on embeddedness. Now, but Eskom's own experts have actually dealt with this issue. Dr. Minar has actually dealt with this. And you will find this, sorry, I just want to get to that, the one that you had highlighted. I want to go through, because I remember Justice Collins saying I should identify the pages. So Eskom's own experts have identified the solutions to the problem of embeddedness. So I just want to go through those now.
Yes, which annexure is it to the answering affidavit?
It's AA39. And that is the specific paragraph or pages I want to refer to.
Yes, it's 13619. 13619.
Yes.
Thank you.
This comes from Dr. Minar.
Sorry, let us all just get there for a moment. I see my colleagues are also, so it's 13-619.
Yes. Now, what we will recall, what the court will recall, is that this report was prepared for this litigation. So it's a response to this application. So what he says under the heading, technical solutions for isolating customers for exclusion from load shedding on MV networks. So taking them out of the problem of embeddedness. He says in paragraph 77, there are two possible technical solutions entailing adaptation of the distribution network to enable the targeted or isolated exclusion of customers from load shedding on a MV network. The first option is to upgrade the whole MV network to enable suitability at customer location level, because the way embeddedness works is that the switchability is at one point, but it affects maybe an entire street or an entire township. It says, but you can change this, which is the reconfiguration, by making the switch available at source, in other words, at Baragwanath itself. It says the first option is to upgrade the whole MV network to enable switchability at customer or location level. This entails installing remote-controlled circuit breakers, switches, or smart meter infrastructure at every customer on the feeder. This means all the customers that are not excluded from load shedding, i.e. all those on the feeder that can be shared, can have their supply switched off at a dedicated circuit breaker. So option one, which resolves the problem of embeddedness, is you give Baragwanath a remote controllable circuit breaker or switch, or for that matter, a smart meter.
Sorry, but I wondered about that when reading it. Does it mean Baragwanath has a circuit breaker, or does it mean everyone has a circuit breaker, but Baragwanath is switched differently? So you can switch everyone off except Baragwanath. Because otherwise, if you only have one circuit breaker, you can't, and you switch off, say, south of Johannesburg, then you switch off south of Johannesburg. Whether Baragwanath has a switch or not makes no difference. But if everyone has a switch, and you can remote control which of those you switch off, then you can switch off all the switches in South Johannesburg except Baragwanath's switch.
Yes, I think it's the latter, it's the second.
Yes.
Yes. But the problem, if you look the next one, or smart meter infrastructure at every customer on the feeder. So he seems to contemplate. So when he talks about the circuit breaker, it will be for everyone, but you can keep Baragwanath on and then switch off everyone, because he says the following: by this means, all the customers that are not excluded from load shedding. So I think it's the second of the two postulations that you gave to me, Davis. Yes, but then that must be read together with smart meter infrastructure, which means Baragwanath will have a smart meter. Yes, because it says at every customer on the feeder.
Yes, every customer.
Yes. But it will have to be all hospitals that are, or it will have to be shops and houses, etc. Everyone has their smart meters. But to your question, I think it's the second postulation. It's then he says the second is to install a dedicated feeder for the protected customer, e.g. the hospital, i.e. a line that feeds only the hospital connected to the nearest substation.
Yes, that's what I understood actually reconfiguration meant.
Yes.
That you have direct, that Baragwanath is in a direct Eskom client, as it were.
Yes.
And it has a direct connection, a refigured connection.
Yes. Now, I think the point for our purposes, at least this week, is that Dr. Minnar already answers the problem of embeddedness, and not to block the solution, but to assist the court to come to a just and equitable solution. And then he explains this. He says, the first option is very difficult to assess and cost, as it will in most cases require full network refurbishment to accommodate such changes. So it will have to be an upgrade rather, of the entire network. The existing network infrastructure is inadequate and will require new telecommunications infrastructure to enable remote customer switching and a combination of additional RMUs and mini substations. Adapted feeders will also necessitate the upgrade and reconfiguration of upstream protection devices. So he says it's there, it's too complicated. And then he says the second option is probably the more viable solution, but installation can be very costly and lengthy, and there may be substantial time and cost variability depending on the considerations outlined below. So that is why when we answer this, we focus on not the technical solution, because the technical solution has been provided by Dr. Minnar. We focus on cost and time. You see. And on cost, we go back to the budget and what the law requires for purposes of finding solutions that will address human rights violations, but which cost money. And on time, we are not concerned about when you will end. We're concerned about when you will start. The level of urgency insofar as hospitals are concerned shows that if you actually started the implementation, which by the way, it's interesting because by the way, they themselves admit that this is an option they have been considering. But given the confusion you find at Baragwanath, where no one knows whether they're in or out, shows that the steps that they have taken are not reasonable steps that they have been taking. And so unless an order is given compelling them as per paragraph 3 and 4, and that's really the defense. The defense is about cost and time. But on cost, we have shown the answer from a constitutional point of view and how to deal with the budget. From a timing point of view, the most important thing is they've got to start. And they cannot complain about time because we have had load shedding since 2008. So they have known about the problem. And if they know the problem and they know that there is in fact a solution, they should be ordered to give effect to the solution, the exclusion the exemption. And even when it comes to the cost, it's crucial to look at what Dr. Minnaar says at paragraph 80.
Well, it says it's about 2.3 million per single user for a 1 kilometer link. So if you have 400 hospitals, it's 400 times 2.3 if they're all 1 kilometer and only a basic connection and an available substation. All the other variables will increase those costs.
Yes, but as we say, it may be that in relation to certain hospitals. Yes, that's paragraph 83. Yes. So it says paragraph 82 and 83, but it may be that, and 85 as well. Similar costs can be expected for rural applications as compared to urban areas, as the technology and solutions are similar. Thus, for a customer in a rural area to be excluded from load shedding by means of an MV underground solution 1 kilometer from a suitable substation and indicative minimum cost will amount to approximately 2.3 million rands. Now, so if they know the cost, they can calculate it, and they've got to make the resources available. And what's crucial is they've got to start. And it may be that it's cheaper for them to buy generators. But we don't know, because their own version, when it comes to the alternative remedy, Eskom says we just have not had enough time to calculate the. I wanted the paragraph. We just have not had enough time to calculate what it will cost to provide the alternative solutions in the time available by the time we file this. But the point I make here is that there is no technical reason that will cause a blackout that has been provided by Dr. Minnaar, because Dr. Minnaar has told us the two alternatives that will not cause a blackout. The only reason that stands in the way of granting that exemption is cost and time. But the costing indicative here is already here. It can be budgeted for. The time, it's not important to finish the business. What's important is to start the exercise. It's important to start to arrest the crisis of the human catastrophe that we have brought. So that ultimately means when you actually examine in detail the defense of Eskom, it is completely hyperbolic to suggest that the remedy we are asking for will cause a national blackout. It's complete hyperbole. Yes, and my colleague points out as well at 13621, paragraph 90, where it says, thus, the minimum time for the project process required for installing a single dedicated MV feeder is anywhere between 12 months and 36 months, but it could be longer. Importantly, these estimates are based on the time frame it would take to install the relevant infrastructure for an individual customer. To install this infrastructure at hundreds or thousands of facilities simultaneously would take substantially longer and would require significant resources and coordination. But the key is that it can be done. And you've got to always remember, if you've had load shedding for as long as we have, since 2007, and you have this plan that we show is no plan at all. No plan at all. The plan that they have is no plan at all. And there is no commitment on helping Eskom to get the capacity that they want, which is 4,000 to 6,000 megawatts. And I've shown on the affidavits where the government ultimately leaves us hanging about when the megawatts will be provided. So what are we saying here? We're saying that when you examine the defense of Eskom closely through the constitutional lens, and you forget the hyperbole that we are asking for a remedy that will cause a blackout, you look at what the expert actually says. The expert has given us two solutions and has costed one solution. And he says the first one is too complicated, but the second one is possible, provided I have the money and provided I'm allowed the time and space to do it. And where you have no end in sight for load shedding. So no end in sight for load shedding. In those circumstances, it is not unjust nor inequitable to actually grant the primary relief of exemption.
Yes.
So we
not to limit your argument, but I see we're getting close to 1 o'clock, and I know you and Mr. Dyke had a apportionment argument between the arguments for the plaintiff. How long do you still estimate you'd need?
I'm at the end. I probably need no more than 10 minutes. This was the last of the 5 topics I had indicated. So
yes, that's how I understood it.
Yes, so I'm just going to wrap up in 10 minutes. I can do that when we come back after the lunch adjournment.
All right, and then perhaps you and Mr. Dyke can have a word as well. I think so as not to overexert ourselves, myself and my colleagues, and so that we can give full attention to all the arguments, I think we should take a lunch and adjournment and reconvene at 2 o'clock.
Thank you, my Lord.
And then my colleagues, when we get back, before Mr. Ngukaitobi wraps up, perhaps that will be a further convenient time for specific issues to be addressed from your side. But I think we can talk over lunchtime.
Thank you.
Thank you.
Thank you. Let's adjourn. Welcome back, my sister, my brother. Mr. Ngwatobi. You're currently still muted. There you are.
Yes, thank you, my lord. What I proposed before we took the adjournment, I had dealt with the objection to the relief based on money and time. There is a third objection based on the regulatory framework. That is dealt with in the affidavit of Mr. Correra, Augusto Correra, which you will find at 13-2192. So I just want to ask the court to analyze that affidavit in due course. But I want to select certain passages there that show that the regulatory framework is in fact not against what we are asking for, and properly construed is broadly supportive of the relief that we ask for. So the affidavit starts at 13-2192, and it sets out various categories about what the regulations would require. So if we can start at paragraph 56 of that affidavit.
Paragraph 36, you say?
56. 56. I think let me use yours. So if we are at 56,
there you go.
That is case lines 13-2216.
Yes, 56 and 57. So it says curtailment offers one means of protecting customers with essential load requirements from the effects of load shedding. However, as the conditions for load curtailment indicate, curtailment cannot always be implemented. Curtailment is not an option if the customer is embedded in a distribution framework, and the effect of excluding that customer would be to exclude a significant other load from the load shedding schedule and thereby compromise the system operator's ability to ensure the integrity of the electricity system. But that's not where it ends, because if you look at 57, it says in such cases, and that's where the regulations we say properly construed are permissive. The NRS 048/9 code provides 5 alternatives. So if on the postulation I gave before the adjournment, you have a scenario in which excluding one means excluding many, and excluding many means undermining load shedding. What the regulation then provides for is what they say here are 5 alternatives. First, certain customers can collectively agree to implement curtailment if they can show that they are collectively able to curtail load by the required amount upon instruction from the licensee. Then such customers can be exempt from the load shedding schedule. So that's already one category that shows how feasible the remedy is, because a collective group of customers can be exempt. Alternative 2, customers with essential load requirements can approach their distributors to make alternative load reduction arrangements. This includes agreeing that the customer will only be shared at a certain time slot or for a longer period of time, but on fewer occasions. That again shows the flexibility of the exemption within the grid. Third, technological solutions may be utilized to enable exclusion from load shedding, such as direct feeder, smart meter technology, or curtailment using load limiting relays. Smart meters would need to be installed at every customer utilizing the same feeder as the essential load in order to insulate that load from load shedding. And they say this is not a widespread practice. Again, you can imagine a hospital would fit perfectly within the parameters of the third option. And then 60, fourth, a customer's essential load may also qualify as critical load and therefore be subject to being managed in ways applicable to critical loads, including possibly being excluded from load shedding. Now, we know on this code that already there are certain loads that are regarded as critical loads. we see that from paragraph 62, the way it defines them, where it says 62, 63, 64. I want to just move from this to the following page. Yes, so paragraph 66, so which are the facilities that are entities or facilities regarded as having critical loads. And if you look there, educational facilities are included, water servicing agricultural facilities, potable water are included. Let's just go further. Again, police stations are included, telecommunications are included, hospitals are included, data centers are included, government buildings are included. So they are already recognized under the code as facilities that have critical load. And then you will then see some at paragraph 69 are automatically excluded from load shedding on an unqualified basis. So those exclusions, there are 7 of them. Water servicing power stations, bulk potable water supply, refineries, coal mines, electricity control centers, the union buildings and national parliament. And then there are others that could be excluded but are not excluded on an automatic basis. You will find those at paragraph 74, where it says the other critical loads, because all of the facilities we've chosen are described by the code as critical loads. Some would fall under the automatically excluded, but a lot falls under the not automatically excluded, which you find at paragraph 72. But paragraph 72 already tells you that there is within the regulatory framework the possibility of the exclusions of those facilities that are not automatically excluded, like the union buildings. And then the fourth element of it is when you look at critical load protocols from paragraph 74, which speaks of hospitals, educational facilities, and then it goes on. But if you look at 74, which is 13.2.2.3, says hospitals are expected, and Eskom understands, obliged to maintain their own backup electricity facilities. And then they explain why that is necessary. So firstly, we know under the protocols that hospitals are regarded as a critical load. It is possible to exclude them provided you follow the procedures that are set out in the regulations. So this idea that if you provide an exemption relief, you would be breaching the terms of the license is actually not supported by the expert witness that Eskom puts up. But then you have this alternative where Eskom says a hospital is expected to have its own backup electricity facility. We know as a fact that they don't. But we know as a fact because the nurses and the doctors working in these hospitals are saying we don't have a backup. So when you order, if you order, rather than when you do, but if you order the government to install the backup energy sources, that is consistent with the requirements under the code in any event. And then the same thing you then find at, so that was paragraph 74. I just want to look at the other paragraphs. Yeah, after that. Yeah, go ahead. Okay. The other facilities. Yes, and then at 78 is public schools. And so this is how they put public schools. They say the NRS 0489 code provides that arrangements can be made to limit the impact of load shedding on schools at critical times throughout the academic year through consultation between NERSA and the government. This can entail arranging load shedding schedules to minimize load shedding during school exams or implementing curtailment options. However, since schools are ordinarily deeply embedded in the distribution grid, it is particularly difficult to exclude schools from the load shedding schedule on a permanent basis without impacting Eskom's ability to effectively sustain the security of the electricity system. And in paragraph 79, in her supporting affidavit, Ms. Mukwena explains that Eskom has recently engaged with the Department of Basic Education, but was unable to exclude schools from the load shedding schedule because of the current levels of undersupply of electricity and number and extent of embeddedness of the schools. And then they say at the beginning.
But those exclusions, again, if one reads further on the affidavit, is again not Eskom can't do it without NERSA.
Yes, indeed. Yes, I think the answer that the question we are engaged with, I accept entirely. If you are going to do the exclusion, it must comply with the code. But the point is the idea of the exclusion per se being inconsistent with the code is not true. Because these exclusions are exclusions that could have been done 10 years ago. Come to court because they have not implemented the codes that they are pleading. The same thing with the telecommunications network. And the telecommunications network, as we saw, a telecommunications network is part of the critical infrastructure that Eskom's code recognized as such. And in paragraph 80, they deal with the telecommunications network. But again, it's not an arbitrary thumbsuck choice. It's part and parcel of the critical load that the codes speak about. They say the operators of such networks are expected to maintain their own backup electricity facilities and contingency plans. So the problem is that of Vodacom and MTN. Police stations are expected to maintain their own backup electricity facilities, but we know on the evidence that there is no such. Otherwise, if there was, they would have produced the evidence. The government would have produced the evidence that don't worry about police stations, they are open 24 hours a day. And then water supply systems to industrial plants can be addressed under the essential load requirements and curtailment options. But that's industrial type of water supply. And then they say users of industrial water are also expected to have contingency plans in place in the event of a disruption of such supply. So that's all Eskom speaking, telling us that the code requires certain exemptions. This is the protocol that will have to be followed in those exemptions. But in addition, the condition of the license, you will see this at paragraph 9 of the answer of the affidavit of Mr. Correra, 2194, 132194, where he says it's the condition of the license of Eskom. It's a condition of the license that when we provide electricity to these facilities, they should have their own backup system. And the license is also flexible because it allows exemptions if the following procedure is followed. So it's not a question of impracticality, impossibility of the relief. It is simply that the requirements in the code have never been followed or implemented by Eskom before the applicants brought them to court. Yes, and then the last part is at page 132285, which sets out now the full table on how the critical loads are required to be addressed. So there is no argument, just like it was made initially, where they argued that it's money. Money is not a problem. They argued it was time. Time is not a problem. They argued it was regulations. Regulations are not a problem.
Sorry, you said the table is at 132285.
2285, yes, my lord. It's
you.
called table 5. And now it gives you a full picture of how each of these critical loads must be dealt with. And you will find that the categories we've selected all fall under the critical loads, except small and medium enterprises. But the other categories, the other 5 categories, all fall under critical loads. And so there is no regulatory prohibition that Eskom tries to put up. Now, when it comes to Eskom saying, well, a school must have a backup, that is what we propose, a police station must have a backup. That is the value of the alternative remedy. That's the value of the alternative remedy. Because if you compel the government to provide the alternative energy sources, you are also giving effect to the provisions of the code and giving effect to what Mr. Correra says should be done in any event as part and parcel of the terms and conditions of the license. So when they say to you in argument and in answering affidavit that it is not, the balance of convenience doesn't favor us, because why do you go through this investment only to find that in Part B, there is now going to be a final order? That investment is statutorily enacted. It's required to be done, not on an abstract constitutional basis, but on a tangible grid code basis. So it's giving effect to the terms of the license if you ordered that all of these backup facilities should exist. And it would not be a breach of these conditions if you ordered exemptions, because these are under critical loads and they can all be exempted under the code without violating the regulations. So on all of the three elements, then for interim relief, element one, prima facie right, we come home. Irreparable harm, we come home. And balance of convenience, I've dealt with all three objections, cost, time, and regulation. And I've shown in all of those three, there is in fact no prohibition behind the granting of this order. I had said to the court before we took an adjournment that I was looking for the part where Mr. Derrida, it's now found it at 13-157, page 404, where Mr. Derrida says they have not had time to cost the alternative solutions. You'll find that at 13-157, paragraph 404. So again, there is no problem of money, no problem of time, and no problem of regulations. So we would suggest, therefore, that the court is at large and, in fact, obliged to grant the relief that we seek, either the primary relief or the alternative relief at the very least. If you dismiss the application, we should not pay the costs. This is plainly a matter of high constitutional principle, and we would be entitled to the protections in BioWatch. If we win, on the other hand, it follows automatically that we should get our costs. It matters not whether we get them from Eskom or we get them from the government, but it could be framed as the one paying the other to be absolved. We've had a large team of dedicated, hardworking junior counsel. We would ask for 3 counsel. Thank you, Justices. I'm indebted to the court.
Yes, thank you. My colleagues, I asked beforehand whether there are specific questions, and you indicated no, but let me just ask again. My sister, any further questions for counsel?
No, thank you, Mr. Director. No questions.
Thank you. Justice Nyati?
You covered me, my brother. Thank you.
Thank you. Thank you, Mr. Ngwatobi.
Thank you, Justice Davis.
Action essay, Mr. Dyke. Yes, thank you.
Oh, God, got no sound here. Just my lords, my lady, just give me a moment, please. We're having a minor technical difficulty.
Yes, certainly.
One computer is frozen. Is your volume, John? Just do the volume. I can't find it. Don't worry about that. Just give me volume here quickly. Get Teams back, don't worry. Right, start. Can you hear me now?
Yes, we can.
Thank you very much. Apologies for that. There seemed to have been a minor interruption in the feed. My lords and my lady, We, to a large extent, do make common cause with our learned friends. And so, as I indicated to you at the outset, we will not be retraversing ground which has already been traversed. What we do say, however, is that this matter here is possibly one of the more important matters which this court is being called upon to hear within the context of the relationship between the government, its state-owned entities on the one part, and citizens on the other part. You will note that the third applicant, Action SA, has limited its relief to those entities most affected by the rights to life and the rights to dignity. Those where economic rights are affected, we don't believe, and this is where we differ with our learned friends, don't necessarily require the urgent and necessary protection argued for. We, on the other hand, are of the view that the interim provision of electricity, whether by adjustments to the existing grid, the provision of generators or other electricity producing equipment to vulnerable entities during periods of load shedding, is absolutely necessary in order to reduce the very serious and harmful effect that load shedding is having on the more vulnerable members of society, to marginalized communities, and indeed to the very safety and security of people in this country. Now, I want to at the outset just put into context what we are seeking. We seek the interim relief, and I will get back to that in due course. We will probably work on a new draft order in light of certain of the questions which your Lordship has raised during the discussion this morning. But we are looking at key essential elements. We are looking at the provision of water and a safe supply of water. As the saying goes, without water, there isn't life. Secondly, we're looking at providing electricity to a mere 85 police stations. No more. We are looking at providing electricity to 93 hospitals. No more. The big challenge, of course, is the provision of electricity to 23,000 schools. But the mere number, or dare I say the sheer number, of schools affected by load shedding is indicative of the size of the problem that load shedding causes to the most vulnerable members of our society. I want to deal with the issue of the failure to join municipalities. My learned friend has set it out very well in his argument. We just wish to make one or two small comments in support of what he said. Our case does not deal with the municipal functions at all. The municipal functions are limited to reticulation. What we are looking at is the generation of electricity, which the municipalities then can or can't reticulate. That's an issue that we'll get to if we have to get to it. The primary concern at the moment is there isn't electricity. How do we get electricity? It is obvious and without a doubt that the municipalities have no ability at this stage. I don't know what might happen under the emergency regulations, but at this stage, the municipalities have no ability to generate electricity. So to join them at this stage, we believe the argument of joinder is somewhat of a red herring. That's not what we're looking for. Our primary purpose is to ameliorate the human cost of load shedding. And the question which has been raised a number of times today is, well, what do we do about a constrained public purse? Because that's really what we're talking about at the end of the day. We're talking about the government having to make very, very difficult decisions with limited financial ability to make good on the decisions which it must of necessity take. But unfortunately, those decisions, and I'll go into a few examples later on, miss a fundamental point. And I'm only going to deal with the question of hospitals at this stage. It's no secret that the public health system in South Africa is under enormous pressure. It's also no secret that the various divisions of the High Court at the moment are inundated with medical negligence claims. Many of those claims relate to babies and the failure of obstetricians and or nurses to properly care for children who are born of high-risk pregnancies. It's also not even debatable that the pressure that this has brought to bear on the public health system and the continued viability of municipal hospitals is such that developments of the common law have been necessary in order to keep these hospitals afloat. The magnitude and the law reports are replete with decisions in this regard of these claims run between 15 and 25 to 30 million rand per claim. There are billions of rands in claims still sitting there waiting to be adjudicated. And the difficulty we have is we now quibble, and I use the word quibble, about whether it's important to spend, for example, I think the number was I think it's 2.1 million rand a kilometer to hook up the hospitals to a grid. 2.3 million rand for 1 kilometer.
I don't think it's 2.3 per kilometer. It's 2.3 million for the cost of someone or a user who is not further away than a kilometer for the links, etc., and so on, to a suitable substation. Yes. If it goes on, if it's further away, then additional cost might imply, but I don't think it's 2.3 per kilometer. But be that as it may.
Yes. Whatever that number is, it's relatively small by comparison to the cost, for example, of one medical negligence case arising out of the failure of a hospital to have an incubator available for a child born with jaundice who requires 24 hours under lights and would then live a proper and promising life, which is the constitutional guarantee which our constitution has cast in stone. This is not a right that can be toyed with, and it's not a right that can simply be set aside or ignored or perhaps realized in the future by way of medium and long-term planning, when we're literally talking about 93 hospitals which serve the poorest of the poor, the indigent, and the people most dependent on those facilities for healthcare. Now, it's no stretch of the imagination. The papers have already set it out in detail that load shedding is costing lives. Can we, in a constitutional democracy, allow a failure by an organ of state or a state-owned entity? We're not looking.
Are you muted now, Mr. Benson or Mr. Dyke? Sorry. You're still muted.
Council, you are muted.
Oh, that's it.
Yeah, now I can hear you again.
I'm sorry, my lord. It's and my lady. It seems to me that there's a master override who keeps on muting if somebody talks in the court, or if somebody else says there's a noise in the background, then we all get muted. Sorry, where was I when I went on to mute?
There's no stretch of imagination that load shedding is costing lives.
Yes. Now, it raises a couple of questions, and I suppose the first question that has to be asked is, what is a life worth in rands and cents? Do we have a price we can put on it? Do we have a price for failure of state-owned entities and organs of state to ensure that electricity is supplied in order to save lives? Again, that raises a second question. And the second question which is raised is that the exclusion of these few hospitals, 93 hospitals, is unfortunately arbitrary. I say that it's arbitrary because it is merely the accident of their positioning in the geographical space known as South Africa, which renders them unable to render service to the citizens of South Africa. The question of whether or not they are embedded in a grid is with respect of no moment. It may cause a problem in finding and the way I read the papers, a cost-effective solution. But that is not the way we deal with fundamental rights. It's not saved by the saving provision in the Constitution either. We simply sit in a situation where, and again I reiterate, today is not the day for determining who is to blame, but we sit in a factual reality. And the factual reality is that we can't give content to the right to life in many instances, because there has been a catastrophic failure on the part of either Eskom and or government to take the necessary steps to deal with the problem that faces the country now. My learned friend has dealt in some detail with the question of timing. I just want to suggest one or two issues in that regard. The first is, what has actually happened since the white paper in 1988? What has government done? Because in 1988, sorry, 1998, not 88, my apologies, 1998. What has been done? And perhaps if I could take you to 14 at 159. I just want to call it up.
Is that the affidavit of the president?
No, I think it's the affidavit of Mr. Matashi. 14159. There we go. Where?
Yes, it's Minister Mantashe's affidavit.
That's the correct affidavit. I'm just calling it up. 159. There we go. He starts off at page 156, and he deals with and he sets out the background to the ERA, the Electricity Regulation Act, and he sets out what the objects of the act are, and then he deals with what he, in that capacity, should or ought to do. And he says in paragraph 12, he sets out the powers which he has. And then at 159, paragraph 13, we have a look and see what has actually been done. On the 4th of May, 2011, the then minister published under government notice 399 in the Gazette, the electricity regulations on new generation capacity, which was amended by government notice R1366 on 4 November 2016 and government notice 1039 on the 16th of October 2020. And those objectives are, as my learned friend pointed out, very much enabling. They don't tell the government what to do. They merely enable the government to, for example, at 13.1, facilitate planning for the establishment of new generation capacity. Well, that's a wonderful objective, but what has been done? And Milady, I will return to your question on the government's efforts with Madupi and Kasile later on. And then to set minimum standards for the requirements for the purchase of power, etc., etc. And then we deal with the independent power producer, and that tells us what it is. And then we deal with, at paragraph 15, the integrated resource plan. Now, I think the integrated resource plan, which shall be developed, you'll see that in paragraph 15, I think that it was on the 6th of May, 2010, and that's a month short of 13 years in the waiting. And then when the crisis actually really hit in the middle of 2022, we saw the formation of a National Energy Crisis Committee. We saw an address by the President, and we saw the development of the National Energy Action Plan of July 2022. More than a decade of blackouts, and let's call them what they are, blackouts, affected the people and the economy of this country in a very, very negative fashion. So, what has been done that is concrete? And, Milady, I'm going to turn to the question which you asked my learned friend about in, well, isn't the development of Medupi and Kusile, sorry, isn't that a step in the right direction? My lady, perhaps the better way to address that is as follows, and that is that the question is not whether government has taken any steps since 1998 to address the problem, but rather whether the steps taken were adequate, appropriate, and apposite, given the gravity of the situation which faced the country and which government and Eskom was well aware of. So the question then boils down to this, is whether the government omitted to take steps that they could have and should have done in order for the country not to be in the position which it is presently in. We say no. We say that the omissions of government and its state-owned entity, Eskom, are so egregious, so debilitating, and so disrespectful of the Bill of Rights that the time has come for steps to be taken. It is quite simply the following. Has the government discharged its constitutional obligations? And we say they are constitutional obligations. And the answer is no. We have seen a stumbling approach down an ill-defined path that's led us to the crisis which we are now facing. And let's not downplay it. We are facing an humanitarian crisis, the likes of which this country has never faced as a result of a failure to provide electricity and or water and or medicine and the like. Now, we can break those causes down, as my learned friend has already done, and they are the development of new capacity and generation capacity, the failure to maintain the fleet, the policy of government to keep the lights on at all cost, the failure to expand the network to cater for a country which now must provide electricity, at least a basic supply of electricity, to its citizenry. It goes without saying that you can't take, and let's take a simple example. We've used the car most of today, so let's stay with the car. You can't take a 5-seater car, which you utilize to commute 5 people to work every day, and expect it in 10 years' time, without at least putting a trailer or something on it, to now cater for 50 people. The proposition only has to be stated for the conclusion to be reached that there is a catastrophic failure. But you don't have to decide the whats and the whys. That can be reserved for another day. What we do know is that in addition, and we'll get to Medupi and Kusile, what we do have is an aging fleet which is unable to deliver electricity at 70%. We now know that the EAF is 56%. And now we turn to Kusile and Medupi. Firstly, yes, my lady, to answer your question, a step has been taken. We say too little, improperly, shoddily, and simply not enough. We've read the affidavits filed in this matter. We've read and we know of the budgetary overruns. We know of the design specifications of the boilers and how they failed, about how cooling towers have collapsed. And we say, well, must the citizens of this country pay for that? And at the risk of a teaspoon of melodrama, by infringing their rights to life and infringing their fundamental dignity as human beings? The short answer has to be no. Why must the citizens of this country pay for the absolutely inexplicable failure to properly bring the two power stations, which were supposed to have brought relief to the grid, but haven't?
Refresh my memory, are there indications in the papers as to when Medupi would be fully commissioned? Or
Yes.
And when Kusile would be fully commissioned?
Yes, I think I made a note of it. I think my learned friend did touch on it. If you just give me a moment to just page back. As I understand it, Medupi was...
was that in Conradi's affidavit?
Yes, I think so. It was supposed to have been available, I think, it was commissioned, there we go, it went out to tender in 2015, the first unit came online, the last unit in 2022, but we now know that it has problems with, it has other issues. And then now with Kusile, it was only in 2017 and is still not complete and online, so it doesn't really contribute to the grid at all.
Yes, now my question was there indications when that would be remedied or rectified?
No, not as to when it would be remedied or rectified. As I understand it, that's an ongoing project with, dare I say it, no end in sight. It may well have been somewhat different if we could know. As I understand it, there's litigation over the boilers with the Tachi, yes, and there are other issues relating to the completion of Kusile. I'm probably, and I don't want to belabor the point, but one of the issues which we need to deal with is the fact that the Minister of Health has actually acknowledged that load shedding is impacted most severely on public hospitals. And in fact that it even affects certain of the public hospitals that have alternative backup systems already in place. My learned friend touched on all the ancillary issues which occur, the inability to do testing, the inability to keep medicines cool, the inability to keep vaccines cool, cold chain management, the lifespan of critical medication and the operation of emergency medical machinery and equipment. It also places the availability of theatres at risk. We know that medicine is a very difficult, or healthcare in general is a very difficult subject matter to budget for. But the time you need a hospital It's when the lights are on and not when the lights are off. It cannot be, as the president argued in his papers, that of the 213 hospitals that were considered for exemption, 76 could be exempted immediately and 46 were identified as requiring new infrastructure to allow such exemption from load shedding, and that this infrastructure was in train, whatever that might mean. But his argument to the effect that the remaining 93 hospitals could not be exempted and remain the focus of Eskom's medium and long-term plans is unsound. That ignores guaranteed, inviolable, fundamental human rights. It ignores the current humanitarian crisis, and the president leaves it there. He does not address any further how these citizens should be assisted. But leaving aside at the moment the right to life and somebody who's critically injured and requires surgery, or a baby, a mother who's busy with a breech birth and requires an emergency cesarean section, or somebody who is on oxygen and suddenly the oxygen is cut off. What does the president's proffered answer address in regard to the question of the entrenched right not to be refused emergency treatment under Section 27(3) of the Constitution? You have a hospital, you have doctors, obviously costing the taxpayer money, and they sit and they're unable to provide emergency medical care because their equipment won't come on, their medicines are expiring, their vaccines have failed in the cold chain. The money that is being wasted is simply ignored. The opportunity cost of that money is being ignored. If I can turn very briefly now to the question of the right to education and the issue involving the schools. In the matter of governing body of the Juma Masjid Primary School versus SANO and others, the citation is in the heads, but it's 2011-8 BCLR 761 CC at paragraph 16. The Constitutional Court has made it quite clear and has endorsed the view that societal unevenness must be addressed by, in particular, a radical transformation of public education. How does one radically transform public education if you can't keep the lights on? The constitutional promise and the Constitutional Court's endorsement in unequivocal terms is rendered nugatory by the failure of the respondents, whether individually or collectively, in their various capacity, to keep the lights on. But what makes it more egregious is that the fact that the writing has been on the wall for so long. It's not only the fact that the children are affected when they go to school. That's only part of the problem. It's no answer with respect to suggest, as the president does in his affidavit, I think it's 02, page 26, that schools have been instructed to adjust their timetables to align with load shedding schedules. with respect, that is completely out of touch with the reality, the lived reality of marginalized children. The lived reality of these children is they get up in the early morning and walk many miles to school. There are feeding schemes that enable these children to at least have one meal a day. And then they walk home in the late afternoon. Now, adjust that timetable, please. If you have load shedding, let's say a 4-hour blackout from 8 till 12, or a 3-hour, 8 till 11, or a 2-hour, 8 till 10. And what happens to these children? Are they going to sit at home in the morning waiting to be told when to come to school? Or must they go to school and sit around and wait? And then their normal finishing time of 2 o'clock moves to 3 o'clock or 4 o'clock or 5 o'clock, depending on the scheduling of the outage, and then have to walk home. Now probably at night, and probably without a functioning police station because they're probably in the same embedded grid. To a home with no electricity, so they can't do their homework. Probably to a home where they haven't even got a cooked meal. But it's all right to say that we can just adjust timetables to align with load shedding schedules. Of course, that also completely ignores the lived reality of all South African citizens, other than those who are able to afford to go off the grid. And that is that these schedules are notoriously volatile and labile. One can wake up in the morning with schedule 3, and by 11 o'clock there's an urgent notice that we're on level 6. And then we're on level 6 for 3 or 4 days, and then suddenly it drops to level 2, and then over the last 2 days to nothing. But I'm quite sure we'll be back up there very shortly. How on earth do these children adjust to that? I'm afraid the answer is completely out of touch with reality. But where does that answer address the right to equality of these children? Some of their compatriots, yes, they're in areas where their schools do have backup systems, but they don't. Again, the arbitrary nature of this and its failure to understand the fundamental pillars of our constitutional guarantees leaves much to be desired. It's our submission that these marginalized learners, and unfortunately, I am in agreement with my learned friend. I didn't make much of this in the heads because I understood my learned friend was going to make much of it. And that is, who are these marginalized children? They are primarily poor Black children who are falling ever further behind in the educational gap. What does that actually translate into? Remembering, of course, that our children are our future. It means that we're looking at, because this has been going on now for years and years and years, there doesn't appear to be any reasonable prospect of a result in the next 2 to 5 years. They're going to fall even further behind. That's another whole set of children who have passed through an education system that simply doesn't meet their needs. And we're going to produce another generation of children who are bitter, another generation of children who are going to be reliant on the state for everything, another generation of children who will never have the opportunity to enjoy the benefits and the freedoms and the promise of our Constitution. And that is a direct affront to their right to dignity and equality.
Dyke, while you're on that point,
yes,
and getting not to demean any other consequences of the impact on the rights and the Bill of Rights entitlements of all the citizens, but getting closer to more legal argument. Now, you mentioned all the long period of time, etc. Are you also of the view, like Mr. Ngugatobe, is that this is just interim relief? Because as the argument developed, his and yours,
yes,
the time periods mentioned moved from a year to 2 years to 36 months to beyond 2024, 5, or perhaps to a somewhat indefinite period of time. Is the relief, couched as it is, though, not in effect final?
It's a question my learned friend and myself actually discussed during the break, and I said I would address it. We're in a very difficult position here because the way the relief is currently couched, it's impractical. And that's quite clear. Yourself and the remainder of the bench have already, through the questions asked of my learned friend, indicated that it appears as though the relief may be cumbersome and possibly difficult to define. And I see in the heads of argument filed by our colleagues for the various other respondents that they also take issue with the form of the relief. I think that what we have to look at is relief which is interim in nature, but is of a longer duration. So what we are looking at crafting, and I'm hoping that we'll be able to present another draft to your lordships and your ladyship later on this week, where we will essentially be saying that the relief is interim in nature in as much as the relief should be applied pending the resolution of the load shedding issue. But, and this is the more difficult side of the drafting
but just even to interrupt you there, yeah. It is currently couched as pending Part B, no. But the resolution of Part B is not an end.
No, it's not. It's not even the beginning of the end, unfortunately.
All right, well, if Part B isn't the beginning of the end, is what is asked in the interim, not final in effect, because you want relief saying exclude schools, connect police, lay on alternate energy or electricity for children in schools for an almost indefinite period of time. Surely that is not in the nature of interim to say, well, it's interim, it can be reversed, it's just for the now. I mean, if you supply a school for the next 5 years with alternate energy, that can't be undone by later B or whatever. It might just be replaced by a permanent solution if in the future. But for the next 5 years, that's the solution. It is, to my mind, much closer to final in effect.
Yes, interim in nature, but final in effect. Yes, yes, I agree with that, because what would happen is that the interim relief would actually, what's the word I'm looking, would naturally fall away when the permanent solution was implemented. So yes, it is interim in nature, but final in effect in that regard.
Well, not necessarily. If there's a connection of a school to a new substation, that would remain whether there's load shedding in future or not. So
as
a
a backup.
portion of such relief,
Yeah.
yes, well, it might only be for backup, but a portion of what is then established is permanent.
Yes. But what it also does is it finally places the government on terms to do what it ought to have already done. And that is to make sure we see in all the answering affidavits, well, it's not really the government per se's problem to make sure that the schools have backup generators, despite the fact that they should. That police stations don't have backup generators, despite the fact that they should. That hospitals shouldn't, when in fact they should. That's an egregious failure, we say, and that is where we say the government, and indeed the president, are constitutionally obliged to make sure that their departments act in that regard. To us, it's not a question of where the budget must be found. That's not the question.
All right, but if it is then permanent in nature, the test just changes, but your argument will still be the same.
Absolutely. We would say, and I mean, I'm talking now about the third applicant, is that the difference between interim and final in regard to the requirements, they're really a matter of degree. We say that there is a clear right. Remembering, of course, that we found our relief on dignity and the right to life. We say there is an injury actually committed, and that's admitted. It's admitted. We say that there's an absence of similar protection. There's no other act that we can fall back on. It's not enough to say, well, engage with your political representatives, come to Parliament. You will see in the founding papers, and I think in our papers, that there has been mention made of attempts over the last while to try and get some sort of result. And nothing has manifested, interestingly enough, until these papers were issued. And it's quite interesting to look at the timeline of occurrences which followed the institution of these papers. So the papers were issued on the 23rd of January, 2023. On the 9th of February in Sona, we heard about the possible steps that government was going to take. On the 10th of February, the state of disaster was declared. On the 27th of February, the regulations were promulgated, and Mr. De Ruyter finally told the country at least his side of the story in his affidavit. And then, of course, on the 6th of March, we had a Minister of Electricity appointed. Now, it's amazing that the launching of these papers has had that much of an effect. And in the interim, as we've been at pains to point out, from 1998 until the launching of these papers, very, very little has been done, other than policy statements and plans. And then, of course, the building of two white elephants.
Yes, well, let's not debate whether the papers achieved all of that or whether this just the extent of the catastrophe
Correct.
Also played a role. But you say, so whether it's interim relief, but final in effect, you still have a clear right because
yes,
the rights of dignity and life are affected.
Yes. They are.
And that argument, does that apply to both the direct relief and the alternate relief?
I think we've lost one of the judges. There we go. His lordship is back.
My brother, I can see you, but I can't yet hear you.
Okay, I'm connected then.
Fantastic. So my question was to Advocate Dyke whether the entitlement to relief, although final in nature, applies to both alternatives. That is the direct supply by Eskom or the exclusions, the instructions to the municipalities not to exclude, and the alternative to supply, whether excluded or not.
Yes.
Yes. All right. You say you're entitled to all of that.
Yes, and as I say, we need to do some work on the actual draft order, which we would like this court to make in due course. But that is something that we will do tomorrow and make sure that we have a workable order, one that will be able to be implemented.
All right, but if you want to produce a workable order, surely the other side will also have to have a look at it.
Of course.
So if you say tomorrow, that might, well, tomorrow will still be fine because you have the saving grace of a public holiday.
Yes.
Before we carry on Wednesday. All right.
Yes. Load shedding permitting.
Yes. There's no, well, now that we talk about a separate draft, there's no separate amended notice of motion for the third applicant, is there?
There was, yes, and there is one filed. That's what I said earlier on when I first introduced the matter.
You're asking for limited, they exclude the non-economic or the economic users.
No, what I said was that the last set of papers have been uploaded late. Please pay attention to them.
All right.
It's section 33 in the case lines. There's an explanatory affidavit, and I think the draft order is annexed there. Can I come back to you on where the draft order is? I don't want to slow down proceedings because I see the hour is already.
Yes, you can, of course. Carry on.
Yeah, thank you. I want to just say that, you know, the situation has been, sorry, the draft order is at A57. Sorry, AS7, 18 to section 18. Section 18, page 127. But it mirrors the existing order, but only in respect of the the existing order of the other applicants, and to a large extent it mirrors the sort of promised relief in the regulations. But it will need work. I'm not satisfied with that order after today.
Well, thank you for the reference.
You asked my learned friend, and particularly about the question of separation of powers. I want to draw your attention. It is in I think the heads of there it is here. It's cited in the first respondent's heads of argument as well. And that is the matter of electronic media network and others versus ETV and others. The third applicant finds itself in a really and truly untenable situation that it, on behalf of its constituents, must now again turn to the courts to deal with infringements of its members' fundamental rights. And this difficulty of the separation of powers and the relief which we seek, which has been raised by the bench today, is obviously a question that is a very sensitive question and one which requires a degree of circumspection. Now, in electronic media network, right in the beginning, the Chief Justice, as he then was, in paragraphs 1 and 2, made a number of very pertinent comments. And you'll excuse me if I read just briefly from these two paragraphs. In paragraph 1, the Chief Justice says, ours is a constitutional democracy, not a judiciocracy, okay. And in consonance with the principle of separation of powers, the national legislative authority of the Republic is vested in Parliament, whereas the judicial and executive authority of the Republic repose in the judiciary and the executive respectively. Each arm enjoys functional independence in the exercise of its powers. Alive to this arrangement, all three must always caution themselves against intruding into constitutionally assigned operational space of the others, save where the encroachment is unavoidable and constitutionally permissible. He then goes on to say, in paragraph 2, turning to the executive, one of the core features of its authority is national policy development. For this reason, any legislation, principle or practice that regulates a consultative process or relates to the substance of national policy must recognize that policy determination is the space exclusively occupied by the executive. Meaning, the judiciary may, and this is the important part of this judgment, the judiciary may, as the ultimate guardian of our Constitution, and in the exercise of its constitutional mandate of ensuring that other branches of government act within the bounds of the law, fulfill their constitutional obligations, and account for their failure to do so, encroach on the policy determination domain only when it is necessary and unavoidable to do so. We say today that this rider is of pertinent application. The judiciary today is called upon as the ultimate guardian of the Constitution and in the exercise of its constitutional mandate to ensure that the other branches of government act within the bounds of the law. We suggest that they haven't. That they fulfill their constitutional obligations. We suggest that they haven't. And account for their failure to do so. We suggest that, well, there's a belated attempt at finger pointing. And that in these circumstances, and in the particular circumstances of this matter, this court is not only at large, but it is enjoined to the extent necessary, and it may only be a small extent, because the relief we seek is not changing policy decisions, as my learned friend pointed out to your lordships and your ladyship. It has now got to the stage where it is absolutely necessary and utterly unavoidable that the judiciary must step in.
Mr. Dyke, I remember reading the case, but I can't find it now in your list of authorities. Just give me the reference again. It's electronic media versus ETV.
Yes, and it is the easiest reference would be.
He hasn't cited it in his list.
No, it's in the first respondents heads, I said, but I'll give you the reference.
Okay.
Yeah, I also couldn't find it in that list. Just give me the reference.
Okay, it's 2017-9.
Yeah.
BCLR.
Yes.
1108. It's a constitutional court decision, and I'll ensure that my attorney sends a copy to your registrar this afternoon.
You can just upload it as well under your list of authority.
Thank you. It's just the first respondent. The first respondent at page 23, 163 quotes at length from the judgment and brings to the court's attention paragraph 3. And paragraph 3 is also important. Paragraph 3 says a genuine commitment to the preservation of comity amongst the three arms of the state insists on their vigilance against an inadvertent but effective usurpation of the powers and authority of the others. Absent that vigilance, in this case, a travesty of justice and an impermissible of intrusion into the policy determination terrain would take place to the grave prejudice of the executive or even the nation. We don't invite you to go that far. We merely say that there are, unarguably so, impermissible violations of fundamental human rights. Now, I realize, as does the third applicant, that this places the government in a terribly invidious position, and probably a very embarrassing position, because what in effect the relief we seek does is that we prioritize certain vulnerable sectors of society above those which we feel are perhaps not as vulnerable. And in effect, what we're doing is we're asking for performance. And we say it's very difficult to place a hierarchy of rights, but thankfully, we don't have to do that. The courts have already done it for us by prioritizing the right to life and the right to dignity. They are the most fundamental and the cornerstone rights, respectively, in our Constitution. At the moment, if I read...
No, but on that point, now I remember also where I saw the matter. You're right, it is in the first respondents' heads, and when they deal with separation of powers, and I think refer to the same case you now refer to, they say the applicants disavow any intention to prescribe to government how electricity should be generated, but their papers belie this. And the first one, to prioritize some institutions and facilities of critical essential loads over others. Now you say, well, the answer is you just prioritize the fundamental rights of dignity and life above others, and you say courts have already determined that. But then they say the ongoing, it asks the court to direct the allocation of substantial resources to meet immediate needs of the priorities the applicants determined, that you say the courts already decided, but overriding Eskom and the government's determination of the allocation of those resources, including ongoing engagement with vulnerable institutions not included in 3 and 4, and the disaster management regulations promulgated interventions to address that crisis. Have a different list of institutions that require priority protection from load shedding. I haven't examined that now again in reading the heads, what that list is, and whether it is just also other vulnerable segments of society beyond those in hospitals. And if it does so, it says, well, now you're encroaching. Now I hear what you say. Some are serious to life, but there's more than just that. And now you're prescribing beyond what a judiciocracy should do, and what a democracy and parliament should do.
Let me possibly try and address that by saying the following. Yes, we are asking for, and we would say, a small trespass. And the extent of our trespass is one which is constitutionally backed. We say that you can't, for example, prioritize electronic media, or I'm trying to think what it was. One of the ones was communication networks. You can't prioritize that above life. You can't, for example, in the case of children and their right to education, which is already in the Constitution, at least a basic education. But you can't close your eyes now to the fact that in all matters where children may be affected, their rights are paramount. And the court, sitting as upper guardian, is aware of that, and the law reports are clear in that regard. And we ask no more of this court, no more of this court.
No, but
than to focus. Sorry,
but the answer of the government in their head say, look, the disaster management regulations lists essential infrastructure, and it goes wider than this. It includes, for example, other health infrastructure, say, for example, elderly and people with disabilities. It includes military health facilities.
It does,
It
yes.
includes further water infrastructure, including water treatment plants, etc., beyond just, the municipal ones mentioned. But we have a plan, they say, to engage all of those, and that is the policy, and that is what the separation of powers say the government should do. If you now, as a court, come and cherry pick some of these because 13 or political parties or 19 applicants said the court must do so, then you overstep the line, and they say then you get into the separation of powers danger.
Yes.
That's their argument.
That is their argument, and their argument, as I say, has a degree of validity to it. But we're not asking the court to replace the emergency regulations. We're merely asking the court to grant us relief which is in line with the emergency regulations, and we're also asking the court to take cognizance of what Chaskelson, as the president of the Constitutional Court in its second case, Makwanyani, said. The state has to demonstrate a respect for life, for the right to life, in everything it does. Everything. And they're not.
Yes, but you're also aware of later cases which says, but if a court now feels a need to protect society and therefore encroach, to use that word, on the terrain of government and cross the separation boundary, it must do so as specifically and as limited as possible.
That is correct. And what we are doing is we are asking this court to prevent mere lip service to the regulations by giving some teeth to the regulations insofar as those regulations relate to the right to life and the right to dignity. We're not asking for more than that.
And you say the relief, well, you say will still be better formulated in
Yes.
a later draft, will not clash with the 27 February disaster management regulations.
No. No. In fact, it will be in line with it. All it will do is it will ask the court to give teeth to certain aspects of it so that we don't lose lives and another generation as a result of any dalliance on the part of the respondents to in fact do what they have been saying they were going to do for some time now. In fact, my lord, if you have a look at the disaster management regulations, I think it's regulation 4, you will see that to a large extent, the wording, dare I say mimic, but is very similar to the relief which we sought before those regulations were promulgated. They cast the net merely slightly wider. And they are perhaps less committal as the applicants are in seeking this very, very fundamental relief. And insofar as, my lord, the later cases are concerned about the ability to trespass on rights to a very limited extent, as I understand it, I don't believe that goes so far as to trespass on the right to life and dignity being non-derogable, even under a state of emergency.
Yes, no, and also to trespass on rights, to trespass on the terrain of government.
On the terrain of government where it affects rights, yes.
Yes. All right, no, I just raised that when you referred to electronic media. I'm sorry to have interrupted you otherwise.
No. If I could just go back to my notes, I don't think I want to say much more, my lord. I want to confer just briefly with my junior, if you don't mind. Can we go offline just for about 30 seconds and we'll be back?
Well, if it's 30 seconds, you can just mute your microphone,
Thank
your
you.
camera, and we'll wait for you.
Thank you very much. I'm indebted to the indulgence. I tried to stay within the 30-second limitation.
Thank you, Mr. Dyke. Yes, we appreciate that.
Thank you very much. My lords and my lady, just briefly there, my junior draws to my attention that there are a couple of things in other people's heads that we just need to deal with insofar as they may affect us and may have some influence on anything. The first is you will note when you have an opportunity under Section 33 to read the later affidavits which have been filed that we, I'll talk about the third applicant now, did not contribute to the founding affidavit. And you will see why. It's explained fully there, but we have, as best as we possibly can, built our arguments around the papers that have actually been filed. You know that we will seek more limited relief, as your lordship pointed out earlier on. There's a complaint apparently about some of the heads being filed late. Our replying affidavits and our heads were filed timeously. Sorry. The third applicant's replying affidavit and heads were filed on time, and I'm asked to please extend our appreciation for the apology which was tendered for our possible omission. I know it wasn't done on purpose. And then finally, my lord, in regards, and my lady and my lord, the last question I want to deal with the case is, of course, the question of costs. The question of costs, we agree that this is a matter that raises probably one of the most important constitutional issues the court has had to deal with in a long time. And we say that the Biowatch principle is applicable. And we say that if indeed there is going to be a cost order at this stage, I'm not sure if this is actually the appropriate time for it. It's probably better to have reserved the costs till the hearing of Part B. But in the event that that costs are argued, and I see that they are asked for in the Part A relief by certain of the respondents, that no matter how the matter pans out, costs should not be awarded against the applicants, because we are, in this case, litigating against state parties and state-owned entities, and the matter has a genuine constitutional import, and the litigation has been undertaken on a very grand scale by the respondents, and we've had to produce what we've had to produce in very limited time spans, and on very strict budgets. So we're not litigating with deep pockets.
Yes, all right. So if you lose Biowatch, if you win, decide whether to reserve costs, or if you're successful, costs follow the event. 3 council because you're on a limited budget otherwise and don't have other resources.
Thank you very much, my lord. That would have been it in a nutshell.
Thank you. My sister, any questions for Mr. Dyke?
No, I just didn't want you to make his case for cost.
No, those were just his alternatives.
Yeah, that's fine.
My brother Nyati?
No, thanks. I am covered.
Thank you. Thank you, Mr. Dyke.
Thank you. I'm indebted to your lordships and your lady.
Mr. Bum, you know, during the case management meeting, I thought, well, applicants one day, respondents one day, and on the third day, say a half day for replies. But Mr. Ngukatobi particularly convinced me to say, no, you'll agree on hours and so on, and it might not even be necessary for the third day. I think he was supported by Mr. Tsatsawani. But I'm wondering, I see there's only 25 minutes left. Do you want to start, or would you consider having a fresher bench on Wednesday morning?
Can I certainly am always fresher.
I'm sorry, I can't hear you. You're very, very faint.
Can you hear me now?
Still very faint, but yes, I can.
Okay, is that better now, Joseph?
Yeah, but look how my sister Carlos also leans forward. It's better, but not fantastic.
Is that any better now?
Marginally.
Now?
Yes, thank you.
I'm always amenable to a fresher bench, and I'm amenable to a fresher self. But can I make a few comments, because I think it's important in light of the way the argument had developed.
Yes.
It would also assist, I would hope. I always think I say things which assist. I might be quite optimistic about myself, but I think it may assist in anticipating my fuller argument on Wednesday. There is something that arose more starkly during the address of my learned friend, Mr. Dyke, which I think is quite important. The history of this matter, the history of the set down, the history of a part A and a part B, the discussions before the Deputy Judge President. We had raised the question of whether or not there should be a part A in circumstances where the part B was an expedited hearing for a full hearing on final relief. You opened the debate earlier today because coming into court in this interim hearing, or this hearing for interim relief, the applicants had still sought what they said was interim relief. They appreciated during the course of the discussion and debate that what they're seeking is not really interim relief. And in fact, a lot of what they argued is underpinned by many of the same legal and policy considerations when you'll truly be dealing with final relief in a few weeks' time. It's the same bench that's going to be dealing with it. Now, I just want to make one thing clear. Nothing I'm saying is to score points, because we accept, we recognize that the matters that you are dealing with today, Wednesday, and in the first week of May are incredibly important. I want to take one thing out of the debate, and I want to take it out of the debate fairly quickly. Are there rights which are being impacted upon? The answer has to be yes. But that's not the end of the inquiry, but the answer has to be yes. Is load shedding desirable? Well, I don't even have to ask that question. Is there a history leading up to where we are at now? Our affidavits say there is that history. Going back to 1999, a series of bad decisions, misjudgments, incorrect choices, corruption, false in maintenance, a whole series of issues have led us to the stage where when you talk about load shedding, it's become part of our lexicon, nothing for us to be proud of. Awful. Are there adverse consequences? There are across the board. What you are being called upon to do, though, against that background, which nobody can dispute, is to make a decision on whether what is being sought now, coming into this hearing, and I want to emphasize it, coming into this hearing, A, can be granted on what's before you, B, and this is quite important, would have the effect not of resolving the problem, but of exacerbating the problem. Now, I've heard phrases like hyperbole, I've heard phrases like embeddedness is of no moment. I'm afraid we're not in a position, none of us, in this debate. We're not in a position to ignore what is being said by the applicants about the implications of load shedding, because a lot of it is correct. They, I'm afraid, should not be ignoring what we say about dangers which may exacerbate the position. This is one time where people should be listening to each other. And when you look at the papers, you will come to the conclusion ultimately that you cannot, on any test, simply wish away the difficulties with implementing the relief they seek. And I'm going to talk about the relief they presently seek. I'll come to what was said to you about an amended notice motion. B, you're not in a position, and they should not be in a position, to simply wish away the implications and potentially aggravating situation that could come about in granting the order they seek in the notice of motion. Now, I'm going to emphasize it because I'm going to go to the notice of motion of both of them. They talk about perhaps adjusting their notice of motion. It's not as simple as that in this particular instance, because every potential solution they put up that they would want you to make an order of court would in and of itself potentially require explanations about why it can be done, why it can't be done, why it needs to be done in a different way. So it's not a simple thing as in an amended notice of motion, we're going to ask for slightly different relief. The grid is too sensitive to believe that you can simply toy around or play around with the relief you've asked, and it could happen, and that you can grant it without an opportunity of those against whom it's being asked to deal with and explain what those consequences are. I want to go on to a next point, the Electricity Regulation Act. You've been told a lot about legislation and the like. We all know the Constitution has got a whole series of fundamental rights. That includes life, that includes education, no question about it, that includes health. But at the end of the day, the Constitution recognizes that all of those rights are balanced because there are limitations of rights. And one would hope that in relation to electricity, we had been in a position where there was no need to balance out anything. We would love to have had a continuous flow of electricity. And I'm going to deal with arguments about the history because that's part of the reason why we would say to you, simply giving the relief that they seek in these proceedings doesn't help one, but it potentially works in some. But let's just look at the objects of the Electricity Regulation Act, and licensing Eskom is something that was done in order to assist in fulfilling those objects. Section 2A and 2B sets out some important objects. It's about balance. 2A talks about achieving the efficient, effective, sustainable, and orderly development and operation of electricity supply infrastructure in South Africa. Efficient, effective, sustainable, and orderly development. You can't achieve that if you're going to be looking for piecemeal solutions, and I understand in important respects. But if you're looking for piecemeal solutions without looking at the effect on the entire grid and the system. 2B, ensuring that the interests and needs of present and future electricity customers and end users are safeguarded and met, having regard to governance, efficiency, effectiveness, and long-term sustainability of the electricity supply industry, and within the broader context of economic energy regulation. Now, amongst the things you would have read in the papers is that the history of the manner in which generation, distribution, transmission and distribution have been dealt with, which includes maintenance, has brought us to where we are at now. There's no easy answers out of it. That we have to get out of it is a fortiori. We have to get out of it. It speaks for itself. Question you've got to ask yourself is the relief they seek taking us on the path to getting out of it, or does it upset the apple cart in a manner which goes against the objects of the ERA? Not really the objects of the ERA.
Sorry to interrupt, doesn't the alternate relief sidestep most of the objections you now mentioned?
Regrettably not. Regrettably not, and I'll come to that. And that's why I say to you, what I've got to deal with now is the the relief as it is sought. I want to take you through it, get to the alternative relief. My learned friend, Mr. Duplessis, is going to deal with it. But can I say this? In the manner in which it ultimately was articulated, the alternative relief, it now becomes the primary relief. It goes to the question of generation, which presupposes, remember, generation in the event that there's load shedding. So in other words, its premise is there will be load shedding. Its a conclusion is like you have a generator in your back garden. It's going to mitigate against it, and it raises a whole number of different considerations. And just bear this in mind. When you hear me, I'm arguing the case for Eskom. I'm not arguing the case for the government. And I want to emphasize it because much as there's a desire to wish away the question of separation of powers, Eskom's mandate is different from the government's. Eskom's mandate is what it has been established for, what it is licensed to do, and what it is going to concentrate on. And that takes me to the next point. And I'm going to deal with this more fully on Wednesday. But I want to emphasize this. There's a duty to generate sufficient electricity. Has it been fulfilled historically? It has to be, the answer has to be no, otherwise we wouldn't have been sitting here today. Where does that responsibility lie? We know from legislation where it lies. Generation is a government function. The relief that is sought directly implicates Eskom because it talks about an immediate halt to load shedding in the first instance. I'll come to the alternative. And Justice Davis, we can't simply jump to the alternative because that's what they still primarily seek. And we haven't yet seen any amended notice of motion.
No, I only asked for the alternative because your initial comments were sensitivity of the grid relation.
I'm coming to that.
And the alternative was more, as you said, generation in the backyard of the hospital solution.
Can I just say this? You know, one of the things I would be concerned about is in relation to a serious problem if we slip into simplistic answers. And I don't say that with any disrespect. And I'll illustrate it to you when I come to the alternative relief. But I want to deal with the fundamental fault line that we sit with at this point in time. So the starting point is relief, which I'm going to go through very carefully on Wednesday. But the starting point is relief, which requires that there's a cessation of load shedding in relation to certain types of customers or certain areas, hospitals, schools, etc. Now that directly impacts on something that, as the government in its generation function, but Eskom has got to manage constitutionally and through its license and through the NERSA codes. And that is balancing the grid, supply and demand. Can't wish it away. You can't deal with it as lightly as it has been dealt with by the applicants. And can I say this? When I deal with the applicants' arguments, I don't want anything to come across or to be read as suggesting that the concerns they raise about the implications of the positions the position we're in at the moment are not serious. They are serious. They're legitimate concerns. What I'm addressing you on is whether the solution they come to court for an order is the right solution, because Eskom says, first of all, it's impossible to achieve. Secondly, if you were to force it upon them, you do risk a collapse of the grid. And this whole thing about suggesting that it's a scare tactic is unfortunate in the circumstances, because whenever you look at risk, you've got to assess risk against consequence. If that risk is minimal, but the consequence is disastrous, you've got to take that risk seriously. And when I take you to their own experts, what they'll say to you is if there's a planned shutdown of the grid, that's never going to happen. It will take about 2 weeks to come up again. 2 weeks is a disaster to be completely blacked out. But they say if it's unplanned, if it trips, their own expert says, nobody knows how long it could take. It could take years. Now, let's not tempt fate with the seriousness of the consequence. Let's not be lighthearted and take lightly the warnings by suggesting that, as has been put, that these are just scare tactics or the like. They're not. And this is certainly not hyperbole. The evidence that you have before you, by people, not by somebody who's writing from the outside, who's not been involved ever as an expert in managing the grid, in balancing the grid, but by the people who are in a functional capacity working at it all the time, whose expertise has not been challenged, and part of whose reason has been referred to in the applicant's argument. Don't take that lightly. I'm going to go through what they say. We should look at it really seriously.
Now, I saw you mention that in your head as well. These are the people on the ground, as it were, working with the nuts and bolts of the Balancing Act. Now, I thank you for the comment and raising those issues up front, particularly regarding seriousness, the rights, the history, etc. Before we adjourn, after you've raised this, and where there is now the spectre of either an amended notice of motion or a suggested amended draft, it'll be, as I understood, Mr. Dyke, no later than tomorrow. Of course, the parties will talk to each other and not continue a simple adversarial stance to say, thank you, I've received your notice, I'll address it on Wednesday. I would assume, as you also said, if it is, the parties are serious about solutions, that they will at least talk to each other. As I understood also, though I haven't been part of it, how the parties talk to each other, how this application morphed from a urgent application to a special allocated application. A last thing before we adjourn, seeing that there is now a day in which to perhaps talk to each other, is I previously raised the concerns and I addressed it with my colleagues earlier as well, and I'm going to raise it now again so that the parties are not unaware of it. If a large portion of this relief is also dependent on what might be raised in B, or if a large portion of what is raised in B also impacts on what we are called upon to decide now, and also if such a large portion of the papers, even in B, are delivered at a late period in the day, not the fault necessarily of anyone, but if we are to receive last heads of arguments on the 2nd of May, but called upon to start hearing what all you councils say is one of the most important issues now in our society on the 5th of May, I again raise the question of whether you are all married to those dates and whether they should remain as cast in stone as they currently are. I raise this for your considerations. Having regard to the nature of the matter, the extent, etc. To get last heads on the 2nd and start hearing a matter like this on the 2 days later is generally to be avoided.
But can I say this? The one thing I want to assure you.
I'm sorry, I again have difficulties in hearing you, but Mr. Baum, I am quite assured that we will have less difficulties in even hearing each other when we see each other Wednesday morning in court 4E.
Can I say something with the hope that you can hear? I'm not going to go into the merits now. I'm pretty certain we will, during the course of receive something by way of an amended motion. You can be rest assured from our side, we will engage with whoever we need to engage, and then we can pick up on the matters. And that's really what I was going to say on Wednesday morning.
Wednesday morning. Yes. Thank you, Mr. Tsatsawane. The same. I haven't even had the benefit of hearing you today, but as the next respondent, of course, see you Wednesday morning in 4E, and we'll continue whatever developments or debate is there necessary.
Yes, that's correct. We will engage in particular with as far as the proposed amended relief is concerned. I think we just want to impress upon our learned friends to engage with us on it as soon as possible, because a big chunk of our argument goes around the fact that the relief that is being sought as currently formulated is not is bad in law. So the sooner they start engaging with us on that, the better.
And it's for that reason you already characterized their amendment as an opposed amendment.
I'm going to leave it just there.
No,
but we do foresee problems with it.
All right.
You might imagine certain things are embedded in this matter, so we can't.
Well, I thank you all for your participation. My sister, my brother, I'll talk to you as well. But let's adjourn for now.
As a please.
Thank you.
Azar, are you still there? No, gone.